Good morning. It is Tuesday, October 8th. It is 9:05, and this is the Energy and Carbon Management Commission for the state of Colorado. We will start with a roll call.
Commissioner Ackerman,
Here.
Commissioner Crofts,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
and Commissioner Shea.
Here.
Mr. Chair, you have 5 commissioners present.
Very good. And obviously, I'm here as well. So good to see everybody, and welcome back. We are taking up the Cumulative Impacts and Enhanced Systems and Practices rulemaking. That is docket 2406000 or 00145. Just to reset the stage, folks, we've been working on this for many months. And then we've been working on this for many weeks over the last few weeks, starting on September 3rd through today, which is October 8th. And where things line out, we had done deliberative thoughts for a couple of days, about a week and a half ago, to our staff, and that was based upon all of the written filings and the rebuttal filings, as well as all the oral and written testimony from our stakeholders. We want to, again, sort of recognize the work of all of the folks in the state of Colorado that have provided information, analysis, perspective to us on this important rulemaking. We took a break to allow staff an opportunity to take the initial deliberative thoughts, which weren't final by any means, and provide back to us a red line to accommodate some of the thoughts and concerns that we had during that initial deliberative thought process a week and a half or 2 weeks ago. We are now back on Tuesday the 8th. We have today set aside, and if necessary, we have next Tuesday, I believe, October 15th, set aside for additional discussion and deliberation amongst commissioners. In speaking with staff about this, I want to applaud staff for the excellent work and efforts. It just goes beyond saying how much time and effort staff has put into collecting, divergent and at times convergent thoughts of commissioners on a lot of really important topics. I, for one, have been in this position for a number of years now and was director before, and I can thoroughly say that this has been a very important rulemaking that has incorporated a lot of thought into it. We've pivoted from a couple of different statutes that we've received from the legislature, and I think we're trying to do a really good job of meeting the intent of the legislature with regard to cumulative impacts, enhanced systems and practices, and while it's not in the title, also incorporating in protections to disproportionately impacted communities as required by the statutes. In discussing with staff next steps, I believe that AAG Stafford and Ms. Trask are now available to daylight to us and perhaps share screens. I'm hopeful that you've got a PowerPoint to sort of at a high level summarize the places that you tried to bring the draft based upon the information provided to us. I also understand that we have now shared to the portfolio the red line draft that we released as of 8 minutes ago. And so, number one, let me confirm, is that true? Is the red line draft in the portfolio at this point?
So in the portfolio, in a file folder named October 8, 2024, I have included the red lines that AAG Stafford provided to me this morning, and I'm in the process of uploading the additional documents that the chair had requested.
And once you're done with that, Hearings Officer Jacobs, if you could share that in the chat, that might make it easier for people that maybe are not in access to the portfolio. They can bring it up on their computer. So give us another 5 minutes or so, and then we'll have the document, the red line documents from staff, I created some red line documents around 604 and 316, and I also put together kind of a layman's Word doc of explaining the proposals that I'm advocating for on those areas, and I'm ready to go through those a little bit later this morning. So with that, Ms. Trask and Ms. Stafford, again, thank you so much for all of your efforts over the course of the last year, but in particular the course of the last couple of weeks in generating yet another red line for our consideration.
Thank you, Chair. Good morning, commissioners and participants. Ms. Stafford, if you can share our slides, I'll start walking through them. And commissioners, we'll make sure that these slides are available after this presentation so that they can also be added to the portfolio. So we'll do just a short walkthrough this morning of the newest draft rules that have just been issued. We would like to clarify that this draft is not totally complete. We have a couple of questions remaining that we'll get to at the end of this presentation. But what I'd like to do for the next half an hour or so, walk through the goals that we set out for staff back in, I think, the beginning of September with our first presentation, walk through the changes between the August draft rules and the draft rules released today, reconfirm some of the distances set up in the distance matrix, and then walk through a couple of remaining questions or ideas that staff would like to get confirmation from commissioners on. At the end of the presentation, we also do have an appendix showing the commissioner's initial consensus list that was issued, I don't remember which day, but a week or two ago. We've got a crosswalk to indicate where those commissioner directions to staff have been addressed in the rules, just to make it a little bit easier for people to find those. So next slide, please. So in our initial presentation back in the beginning of September, we had a slide that identified some goals that staff was hoping to meet through this process. Big picture, did we meet them? Yes, I believe that we did. Are these rules perfect? No, but they're good rules, I believe. I think that through today's hearing and the 15th, if necessary, we'll be able to continue to refine some of the unknown questions that continue to exist. And there is always room for improvement over the long term, but I do believe that these draft rules today largely meet the goals that staff set out for ourselves anyway. So those goals were to adopt rules that evaluate how the incremental impacts from oil and gas operations contribute to cumulative impacts as a whole. This is the evaluate piece. We've got direct language on evaluation in Rule 315B and for OGDPs and non-OGDPs, Form 2s and subsequent operations. And then we also evaluate incremental and cumulative impacts for CAPS in Rule 314E10. For addressing the impacts, some of the ways that these rules will work to address impacts are through the ESPs and NOx timing limitations and additional actions to further reduce NOx. We've incorporated the avoid, minimize, and mitigate hierarchy throughout the rules. Sort of generally, we've taken an approach where avoidance is met through incentivizing the proper siting of new locations away from sensitive or impacted receptors. Minimizing impacts that cannot be avoided, that happens through the application of best management practices and enhanced systems and practices. And then for those impacts that cannot be avoided or minimized, we would mitigate those adverse impacts. And one of the ways to do that is through the incentivization of beneficial impacts that would then offset adverse impacts. As the chair noted, we do have a lot of additional new protections for disproportionately impacted communities. Specifically, we've expanded a lot of opportunities for community input in various formats. Additional information is required for applications that are near disproportionately impacted communities. And same with the enhanced systems and practices, which have been further delineated based on proximity to disproportionately impacted community members. And then the general pollution reduction efforts between ECMC and CDPHE, we're finding a lot of alignment with our use of AQCC's NOx and greenhouse gas intensity target review. So those were the 5 goals that we set out to meet, and I believe that we have met them. Next slide, please. So I'll just jump in now for the definitions. The first couple of slides here for definitions are those definitions that were changed between the August draft and the draft issued this morning. So area of evaluation, the definition didn't particularly change. This was more just renaming that definition from the original name of impact area, now being called area of evaluation. Rule 315A has, that's where the area of evaluation lives in the rules. We'll walk through that a little bit later in the presentation. Next slide. Biological resources. This was the direction given to staff from the commissioners a week or so ago. We'll have additional language in the statement of basis and purpose, the companion document to these draft rules that will be coming out shortly. That statement of basis and purpose, or SBP language around biological resources, will have some additional thoughts about the commission's intent to create a working group that would then further review, analyze, and make recommendations on biological resources. Whether that changes the definition or just changes how that definition is applied in the rules will be left up to that working group. Next slide, please. So we've got the new definition of Colorado EnviroScreen. This was because, as directed by the commission, staff did remove the use of the term cumulatively impacted community. Because the CIC definition was removed, we had to then tweak the Colorado EnviroScreen definition. And I see AAG staffer, did you want to add to that point?
Just to reiterate that we added this new definition because as a result of removing the cumulatively impacted community definition, we did not have a set place in the rules that referenced specifically the specific version of EnviroScreen that we are dealing with, that we need to deal with due to incorporation by reference issues. And so in making our revisions over the last week, we found it necessary to define this particular term, and so that we had something to rely on in the rules as a result. So that's all I wanted to add. I think Ms. Trask got it.
Thank you. Next slide, please. So the definition of disproportionately impacted community, we've incorporated the whole definition that is in statute. Whereas in August, we had sort of bits and pieces of that definition. Now we're incorporating the whole definition. There will be additional language in the statement of basis and purpose describing the relationship between ECMC and tribal jurisdiction. So one of the prongs, if you will, in the statutory definition of DI communities involves communities that are on tribal lands. We want to provide language in the statement of basis and purpose that clarifies the commission's limited authority over oil and gas operations on tribal lands. And so specifically the prong that we are adding in here, that is that statutory prong, will allow us to use disproportionately or review disproportionately impacted communities to locations that are outside tribal lands. So we'll have some clarifying language in the SBP around that. Next slide, please. The definition of industrial facility, we removed the list of types of operations that was in the previous definition. That list will be moved into the statement of basis and purpose. It is not meant to be an exhaustive list. One thing I do want to note very clearly is that we are excluding dairies in that language in the SBP. So we will note in the SBP that dairies are excluded. I think we heard very clearly from a number of stakeholders on that point. There are a few other definitions that we tweaked a little bit after the August draft. BMPs, comprehensive area plans or CAPs, cumulative impacts, and pollution. Those definitions needed to be slightly updated because of the capitalization of some of the other defined terms. So biological resources, area of evaluation, and cumulative impacts. That's the only change that was made to those. And then there was a typographical error that we corrected in the definition of ozone non-attainment area. Next slide, please. There were a number of new definitions introduced earlier in this rulemaking that have not changed in this draft. It's the same definition that was provided in the August draft. Next slide, please. So jumping into the rules, starting with Rule 224, Community Liaison, we took much of the language that was provided to the Commission by the Green Latinos group regarding the roles and responsibilities of the community liaisons. We've added to subparts B and C and clarified that the duties listed in the rule will include but are not limited to. This was important because as staff endeavors to recruit and hire the first two community liaisons, and as those two new staff members get into their roles and start really working very closely with disproportionately impacted community members, they might acknowledge or come to realize that the duties that they are evolving into aren't quite in alignment with what is in the rule. They will provide services that the members of DI communities are needing. And so we needed to have that limit, duties will include but are not limited to language so that those community liaisons can evolve those positions in real time in the future. We're also adding some language to the statement of basis and purpose, explaining that the community liaison, although they can be involved in a community's negotiation of a community benefit agreement with operators, their role is not to actually conduct those negotiations.
And I just wanted to chime in briefly again to bring some more specificity to the specific revisions that we made to subparts B and C. So in the initial commission deliberations, we were directed to add to subpart B a clause with consideration for experience in regulatory or environmental processes or subjects that ECMC regulates if possible. And in subpart C, we made additions specifically to subpart C11, which was the written consultation and ensuring to incorporate the perspectives of DI community members as part of the proposed oil and gas development plan application. And as Ms. Trask already said, this is largely the language that we had previously discussed with the Green Latinos attorneys. So there should not be much additional change from that other than some grammatical edits as we were ensuring that all of the duties were properly incorporated into that role.
Thank you, AAG Stafford. Next slide, please. Rule 301. So these are the pre-application meetings, involvement with local governments and federal agencies. We took a lot of the proposed language and concepts from Commissioner Messner's draft that I believe is filed in the portfolio. Used his concepts, updated the language just a little bit to better fit the rules themselves. So clarifying in subparts 3 and 4, the local government process, that continues to take precedence in the permitting process where the local government has that process already established. And then in Rule 301G, that's the pre-application meeting. So we provided some clarification around the sort of staff or subject matter technical expert meeting, and then separate from that is the community meeting. For both of those meetings, we clarified the purpose of the meetings, and for the community meeting in particular, when the community liaison would be participating in that. That community meeting is open to the public, but it also would have specified invitations to residential building units within certain proximities, which we'll get to a little bit later. Next slide, please. So Rule 302C, this is the rule where there was a lot of party and commission discussion on whether the director will consider the relevant local government citing disposition or will defer to the relevant local government citing disposition. Per instruction to staff, we are using the term consider. However, we will expand into the statement of basis and purpose some additional language that further clarifies the concurrent process between local governments and ECMC. Next slide, please. Rule 303D adjusted the public comment period. This was necessary, again, with the removal of the cumulatively impacted community term. And we'll look at those distance radii a little bit later as well. And then same thing with who receives the notice. That changed as well because of that removal of cumulatively impacted communities. Next slide, please. So Rule 304B2, this is the alternative location analysis, or ALA. The ALA was added back in per direction from the commission. We provided some clarifying language about when ALAs are not necessary. Those are specifically related to Form 2As that have preliminary siting approval and an approved cap. So we revised that language to make it a little bit clearer when an ALA was not required in a Form 2A. The ALA criteria was reinstated with no change from the current rule. What was added, though, is that locations that don't meet any ALA criteria must now show proof of how they don't meet any ALA criteria. So under our current existing rule, there's no requirement for the operator to indicate that their location doesn't trigger an ALA. Under this proposed new rule, there is now a requirement for the operator to demonstrate how their proposed location does not trigger an ALA. We've also added in requirements for information on transportation corridors and high priority habitats on the ALA maps. And again, removed the reference to cumulatively impacted community. There is On this slide at the bottom, there's a bullet in red, a late staff consideration. As we were working through this revised draft, we recognized that there was a change made that maybe shouldn't have made. And so I'll talk a little bit later in the slides what the specifics are. It's just noted here for your convenience, and then there's more information later in the presentation. Next slide, please. So also now a requirement for the Form 2A that currently exists, 304B7J, the disproportionately impacted communities map. This map is now being expanded. Again, we removed the reference to cumulatively impacted community. The map information is being expanded to include when this map is required. Current rule requires it for any locations that are within 2,000 feet of any residential building units in the DI community. Now this map is required if there are any residential building units in the DI community within 1 mile of the location. So it greatly expands the area of review that would then require this, this DI community map. It also now has a new requirement to provide a distance and a direction to all the residential building units within 2,000 feet of the location. And it also requires a table indicating the number of residential building units that are between 2,000 feet and 1 mile of the location. This will give the commission some better insight on the density of residential building units within 1 mile of the location. And then Rule 304C19, the Community Outreach Plan. This is an existing plan. In this rule, again, we've removed the reference to cumulatively impacted community and then changed the distance for when the plan is required. You'll see a trend here moving from the 2,000 foot trigger out to a ½ mile distance to any residential building unit, or 1 mile to an RBU that is within a disproportionately impacted community. Next slide, please. Similarly, Rule 304D, the lesser impact area exemptions, we removed the reference to CI community and changed the radius that those exemptions are prohibited out to a ½ mile for non-DI community RBUs and 1 mile to DI community RBUs. Rule 304E, substantially equivalent. In the August draft, we had that ALAs and cumulative impact analyses may not be submitted as substantially equivalent. Per Commission's direction, we removed the clause for ALAs. So now the only OGDP information that cannot be substantially equivalent is a cumulative impacts analysis. Next slide, please. Rule 306 and 307, this is the director's recommendation on the OGDP and the commission's consideration of the OGDP. We added in clarifying language regarding the director's and the commission's review of an operator's ability to comply with their NOx intensity target and their greenhouse gas intensity target. We left the language intentionally broad because we anticipate there would be a number of different scenarios that could come up with operators statewide, and so we didn't want to be overly prescriptive. So the language there, it is broad, it's intentionally broad so that the director and the commission both have some flexibility on how they review and make a decision whether to approve with condition or deny an OGDP. Next slide, please. So Rule 308 is the Form 2, Rule 311 is expiration, and Rule 312 is subsequent operations. In both of these, or at least in Rule 308, we removed the reference to cumulatively impacted community. There is another late staff consideration with this. We have language in Rule 312 for subsequent operations, whereby if an operator submits a Form 4 to conduct subsequent operations, the director can require that the operator also submit a cumulative impacts analysis and also a Form 2B if necessary. In Rule 308, we missed one of those pieces. We indicated that the director can request a cumulative impacts analysis if an operator submits a Form 2, and we're generally talking about Form 2s that are not associated with an OGDP. So the director can request a CIA, cumulative impacts analysis. We neglected to add language that the director may require a Form 2B in concert with the CIA. So I flagged for you in red here that we would like to add in language similar to what we added in Rule 312, add language into Rule 308 that allows the director to require a Form 2B in concert with that cumulative impacts analysis if the director deems it necessary. Rule 311 was a big topic of discussion. That's permit expiration. That rule has been left out. There are no changes to current Rule 311 or 312 now. In the statement of basis and purpose, we will provide additional language around the commission convening some sort of a working group to discuss changes to Rule 308, 311, and 312 at some point in the future. Next slide, please. Rule 309C, this is the post-completeness community meeting. We've provided some edits to that draft language to capture the sort of the nuts and bolts of the staff consultation as well as the community meeting. The post-completeness community meeting will be a public meeting, but again, it will also have specific invitations sent out to surface owners and residents within a half mile of the location or within 4,000 feet of a proposed location for those residents that are in disproportionately impacted communities. In Rule 309F, that is the director's consultation with CDPHE. We've changed the language from the director will consult to the director will request consultation. We've also revised and updated the distance radius per commission instruction. Next slide, please. Jumping up to Rule 314, this is the Comprehensive Area Plan or CAP rule. We've made quite a few changes to this rule, so I'm going to walk through it a little bit more slowly. I think it will become clear once you've had a chance to actually read the edits that we're proposing. So one of the important parts of a CAP is the incentivization of a CAP. So in 314B, that lists the rights that are conveyed to an operator if a CAP is approved. Current Rule 314B3 offers that if the commission approves a CAP, the operator need not separately evaluate cumulative impacts for each individual OGDP. There was a lot of discussion over the last few weeks, discussion with commissioners and the parties in the hearings about how to accomplish obtaining the incremental impacts, getting them into CIDR, and also conducting the cumulative impacts analysis. So we removed that language out of 314B. I want to assure industry that we're not removing that right. We've just moved it down into revised rules 314E10 and 11 and added some much needed clarity around this. Additionally, current Rule 315B, where it is a right conveyed that discusses preliminary siting approval, we took the bulk of that rule and moved it down into expanded Rule 314E11. So again, not eliminating those rights, just reorganizing and clarifying them elsewhere in Rule 314. Rule 314D, we changed the term pre-application consultation to pre-application meeting. Next slide, please. Rule 314E3, this is a list of maps that are required as part of a CAP application. In a number of those current rule languages for the maps, we've just made some small clarifications. We did add one new map, 314E3L, that is a map showing industrial facilities, now that that's a defined term. And we've moved 314E3 capital E, the current rule language describes not a map, it describes a description of plans. And so it didn't make sense to keep a description of plans listed in the map header. So we've just moved that description of plans for electrification out of the map section and down into the narrative section in subpart 8. You'll see that once you get into the red line. And then the next bullet there, Rule 314E8, this is where we moved that description of plans for electrification. We already have Rule 314E8, which is infrastructure planning. It made sense then to include the operator's proposed electrification plans in with their infrastructure planning. Next slide, please. So this is a big one, Rule 314E10, evaluating and addressing cumulative impacts. This is where in the August draft, we introduced a new proposed Form 2F, which is the incremental impacts of the CAP area. So this is the CAP version of the Form 2B that is associated with OGDPs. Some of the resource language we updated, minor updates in air resources. In the August draft, we had air resources and impacts to climate. But since we have a defined term that is impacts to climate that is specific to greenhouse gas, we moved that impacts to climate section down into subpart I, where greenhouse gas lives. In the water resources section, we clarified the storage volume data in a way that will streamline the review of that data. In biological ecosystem and soil resources section, we added the Barrens habitats, and we updated the Colorado Parks and Wildlife SWAP reference. That's the statewide area plan. And we notably, we moved the beneficial impacts to subpart J. So in the August draft, in biological ecosystem and soil resources, we had proposed a list of beneficial impacts. These are questions about how many wells does the operator intend to plug? How many locations does the operator intend to close? And how many acres does the operator intend to reclaim as part of this CAP? Those items were moved out of biological resources and moved down into subpart J and given a new name of beneficial impacts. For disproportionately impacted communities, we've expanded some of the information requirements and again, removed the reference to cumulatively impacted community. In both the NOx intensity target and the greenhouse gas intensity target, we removed the controlling interest language. Both of those sections had a short paragraph describing the controlling interest where there's a parent company and a subsidiary company. That language has been removed. And then again, new rule 314E10J is specific to beneficial impacts. So that's the well plugging information, location, reclamation information, and other beneficial impacts that the operator would like to describe in their CAP application. Next slide, please. Continuing in 314E10, we've added a new rule, 314E10K. This is another big one. This is the CAP cumulative impacts analysis. So where the CAP incremental impacts will come in on a Form 2F, which will go into the CIDR database. This rule requires that there will be an attachment to that Form 2F. That attachment will be the CAP cumulative impacts analysis. It includes a requirement for descriptions of receptors and descriptions of impacts and sources of impacts that are already identified in the maps that are required in the CAP. So in 314E3, the maps, it's a visual display of receptors and a visual display of impacts or sources. In this attachment, it's that written narrative that describes the information that is illustrated on the maps. We can think of this generally as sort of the baseline conditions of the greater CAP area. This attachment will also include a summary of the Form 2F incremental impacts. It will also include a narrative summary evaluating, and this is sort of the big moment here, the narrative summary evaluating how the incremental impacts will contribute to the cumulative impacts within the CAP boundaries. That is sort of the whole point of the cumulative impacts analysis. So this is where that is going to live as an attachment on the Form 2F as part of the CAP application. I want to clarify that the focus here is on the CAP area as a whole. So it could be a very large area. We've had a CAP, at least one CAP that was, I think, upwards of 50 square miles. So we're not talking about an area of evaluation that is default to, you know, a 1 mile radius around each location. We're looking at a very high level regional view of receptors and impacts. The reason that why we have to have this high level view is because this has to work for CAP applications in which the operator is not seeking preliminary siting approval. So under a normal, and sorry for the air quotes, a normal CAP, the proposed oil and gas locations can be conceptual. The operator is not required to have an exact latitude and longitude where those locations are going to be. And so in order to accommodate that imprecision of location siting, this has to allow for the operator to provide and staff and the commission to review information that is general to the large scale of the CAP. The site-specific information will be captured on the subsequent OGDPs. And next slide, please. The site-specific information may also be captured here in Rule 314E11. This current rule is called siting information, and this is where the preliminary siting approval process is outlined. We've renamed it from siting information to preliminary siting approval. And we've taken some of those rights conveyed from Rule 314B5 and moved them into this new section. So all of the preliminary siting approval, or PSA, information is now combined together in this Rule 314E11. So I think it will be easier for operators to find all of that information in one spot. So where we've clarified in this new revised 314E11 is that for operators who are seeking preliminary siting approval, their CAP application will require the ALA, the cumulative impacts analysis, and certain location data for each of their proposed locations. This is information that is normally provided in the OGDP, but would be provided in the CAP. The CAP application also requires the operator to submit one or more Form 2Bs that cover all of the incremental impacts for those proposed locations. Again, that Form 2B would normally come in with the OGDP, but in order to, for the commission to understand the impacts and the proposed siting at the CAP stage, we need this very technical and granular information here with the CAP. The benefit to this is that the operator doesn't have to do the Form 2F, which is the CAP-wide incremental impacts. Those Form 2Bs will capture the information that would otherwise be required in the Form 2F. So the benefit for PSA is that no Form 2F is required. And the ALA, the CIA, the location data, and the Form 2B are no longer required with the OGDP because they're being submitted with the CAP. The caveat to this is that if preliminary siting approval is granted and the CAP is approved, then those subsequent OGDP applications that will be coming in, although they don't have to have the ALA, the CIA, the location data, and the Form 2B, the operator does have to include on their Form 2As a list of changes that have occurred on the landscape near each proposed location. Any changes that have occurred in the time between when the CAP was approved and when the OGDP is submitted. So if that's a short period of time, if the CAP is approved and then the OGDP applications are submitted within a week, that list of changes will probably be pretty sparse. If a long period of time has elapsed between when the CAP was approved and when the OGDP is submitted, maybe it's 2 years, then that OGDP, that Form 2A, will require the list indicating what changes have taken place in the landscape. This includes things like new homes are built nearby, new roads are built nearby. The local government has rezoned the area from one zoning type to another zoning type. It could even be sort of natural changes, things like a riverine system, a meandering stream changed its course and now the floodplain is different. Or there was a slump or a slide that changed the topography. So there's a pretty extensive list of potential types of changes that could happen in that interim that the operator will need to describe on their Form 2A. Next slide, please. The public review process, then once a CAP application passes completeness, the public comment period is open. The completeness determination will be noticed out to all residential building units within ½ mile of the CAP locations, or 1 mile if the residential building units are in a DI community. And then we've changed the requirement for the operator to send out those notices from 5 days to 7 days. Next slide, please. So moving out of CAPS and moving into Rule 315, this is cumulative impacts data and analysis. 315A is the Form 2B that has been in the previous, it's in our current rule. We've again changed the name impact area to area of evaluation and updated those rule references. The requirement now also includes a plain language summary of the Form 2B that will be included with the application. And I neglected to mention that in the CAP, so going back to the CAP for a moment, in the CAP cumulative impact analysis, which is attached to the Form 2F, the information provided in those cumulative impacts narratives, that must also be written in plain language. So that's another new part of that. So plain language here as well. Next slide, please. Rule 315B, this is the cumulative impacts analysis. Again, changed impact area to area of evaluation. We've laid out in the new 315B2 the new process where the operator must demonstrate that the area of evaluation is appropriate. The rules do set, per commission instruction, sort of a default area of evaluation, which is for water resources, 2.5 miles from the proposed location, or if the location is within a surface water supply area, it's 5 miles downstream. And then for all other resources, the default area of evaluation is 1 mile. The area of evaluation may be expanded due to the nature, intensity, and scope of operations and potential impacts. The language also allows for the area to be contracted to, but not in the non-attainment area. and only where there is topography that is significantly prohibitive of the 1 mile radius. That again will be left to the operator to demonstrate. The director will review the operator's area of evaluation and evaluate if that area is appropriate. This will be documented in the director's recommendation. And then some slight revision to the language around that the commission will defer to the director's evaluation of appropriateness and can only basically override the director's evaluation if the director made clearly erroneous decisions on it. Next slide, please. Most of the changes in 315B2 again are the references changing the name from impact area to area evaluation. A couple of resource impact descriptions were updated. So per commission instruction, we added the language. I think it may have been, and I apologize if I misspeak here, I think it may have been the hunting and angling groups request to add language about the water quality, requiring information concerning classified uses, anti-degradation designation, water quality attainment status, and causes of any impairment as used and reported by CDPHE. So that is now included in the current in the draft that's released this morning. It's in the water resources impact section of the cumulative impacts analysis. We also added the Barrens habitat to the biological resource review. We added the requirement for the operator to submit, again, that plain language summary of the cumulative impacts analysis. And we updated the language around the review process to allow for different scenarios in which the cumulative impacts analysis might be required. So it's covered for OGDP applications, it's required, but we expanded the language to include cases where the director is reviewing a non-OGDP Form 2, a well permit, or subsequent operations per Rule 312. Next slide, please. So Rule 316, this is oil and gas operations in the ozone non-attainment area. For 316A, we updated the references that we were directed by the commission. That controlling interest language, again, is gone. We will add additional language in the statement of basis and purpose to further eliminate that. And then we've revised the process to streamline the discussion of the director and then the commission in their consideration of NOx intensity target status. This allows for some discretion for both the director and the commission. Next slide, please. Rule 316B, this is the Form 2D emissions intensity assessment. We've expanded this now to include production-only operators. So in the August draft, we focused this rule only on operators who were seeking to conduct pre-production operations in the non-attainment area between May 1st and September 30th. We've expanded it now to include those operators who aren't seeking to drill, but are seeking to continue their regular production operations. We also included much of the language that was provided by Oxy in their various presentations regarding that 20% over compliance for an operator who demonstrates that they are over compliant with their NOx target by 20% or more. Then their Form 2D gets that streamlined review. It requires a smaller amount of information to be provided. For operators who don't hit that 20% over compliance, or operators who are not in compliance with their NOx target, then they can be referred to Rule 316D for additional actions to reduce NOx if the director deems necessary. Next slide, please. Rule 316D, these are then the actions to address an operator's failure to comply with NOx target. We've revised this language a little bit to include consideration of past compliance and an operator's ability to comply going forward, and further explains the actions that may be required based on the type of operations. We did leave some openness to the rule so that the director can assess other actions. We wanted to leave room for the director to. We anticipate that we did not anticipate all the different options that will come up. And so we wanted to leave room for the director to come up with new options on a case-by-case basis. Next slide, please. So Rule 904 then, this is evaluating cumulative impacts. This is specific to the annual cumulative impacts report. We've included now a reference to reclamation information that will be added to that annual report. And we also clarified that the director will consult with CPW specifically, not just DNR, but CPW specifically in that annual report. Next slide, please. So a couple of, going back to the distance matrix, and I apologize for belaboring this point, I did want to flag a couple of instances where I would like to suggest another couple of few small modifications. So the notice of the community meetings, there's a pre-application community meeting, and there's the post-completeness community meeting. The 301G pre-application community meeting is required when a proposed location is within a half mile of a non-disproportionately impacted RBU, or the location is within 4,000 feet of a disproportionately impacted home. In 309C, this is the post-completeness community meeting. The current language is that this meeting is required when a location is within 2,000 feet of any residential building unit. I would suggest changing this to a half mile and to 4,000 feet so that it has the same trigger as the pre-application community meeting. It makes sense if that pre-application meeting is required based on a half mile or 4,000 feet. Then the post-completeness community meeting should also be required based on a half mile and 4,000 feet. So that is one revised distance I'd like to see. Next slide, please. And then for the Rule 309E, completeness notice, current language says, or current proposed language has that the notice goes out to non-disproportionately impacted RBUs within a half mile and within 1 mile for disproportionately impacted RBUs. I would request changing this to 4,000 feet so that it matches the post-completeness community invitation. So the thing about the completeness notice is sent out when the application, when the OGDP passes completeness. The post-completeness community meeting invitation would also be sent out at the same time. So to me, it makes sense to have the same people receiving both of those notices. Next slide, please. Okay, so this one's a little bit weird, and I fear I won't articulate it very effectively here. It will be easier probably once you get into the red line and actually read the language. But going back to Rule 304B2C, this is the alternative location analysis, the ALA. There's a requirement, and it's in the current rules right now. There's a requirement for a data table that when a proposed location is within, in current rule, when a proposed location is within 2,000 feet of a disproportionately impacted community. So this is talking about locations that are outside a DI community, but are within 2,000 feet of it. Then the operator must provide additional information. Somewhere, I think, in our Control F find and change process, we identified this 2,000 feet and we changed it to 1 mile because we did that with some of the other distances throughout the rules. I would like to suggest changing this particular one back to 2,000 feet. And let me just briefly try to explain why. This rule requirement, as currently drafted in our new release as of this morning, says that for a proposed location that is within 1 mile of a disproportionately impacted community, the other information is required. If you think, and I apologize, I should have probably drawn up a graphic to illustrate this. If you think about a map view where there is a location outside a DI community, a proposed location outside a DI community, and it is almost a mile away from that DI community, that location, that Form 2A would require additional information about outreach that is done in that DI community, regardless of proximity to people. So the language that we have in this morning's draft would require additional information in an ALA for a location that can be up to a mile away from a disproportionately impacted community, to discuss outreach that the operator conducted in that disproportionately impacted community. I think it's just a simple oversight where we literally did Control F looking for 2,000 feet, and wherever we saw 2,000 feet, we changed it to a different number. And in this case, it got changed to 1 mile. I don't think a mile is appropriate here. I think 2,000 feet is the right approximation to require that additional information. So I would ask that the commission consider changing this back to the current rule of 2,000 feet. Next slide, please. So this is just a summary of those distance items that I have just walked through. Next slide, please. One other question that I would like to ask the commission for direction on is what I mentioned it earlier. It's in Rule 308. In our draft Rule 312, which is subsequent operations, the director has the ability to require a cumulative impacts analysis and a Form 2B in her review of a subsequent Form 2 for subsequent operations. In Rule 308, the director may require a CIA, a cumulative impacts analysis. I would like, I would ask that the commission consider letting us add in that the director may also require a Form 2B to help in her review of the cumulative impacts analysis of a Form 2A. This is a Form 2. This is particularly important when there is an existing built location that was permitted and built prior to mission change that never had a Form 2B. It never underwent a cumulative impacts analysis. And now if an operator wants to come back and drill their remaining well slots that were approved prior to mission change, we would ask that the director has the ability to not only require the cumulative impacts analysis, but potentially also require the Form 2B for that location. So that hopefully that makes sense. We do have that language in 312. We would just like to also add it into Rule 308. Next slide, please. So to summarize, we've got some additional work ahead of us. This rulemaking process doesn't end by the adoption of rules. I just wanted to flag for the commissioners that in your deliberations throughout this process, you've indicated to staff that you would like to convene working groups, including a working group on biological resources, a working group on sort of the permit expiration question that includes rules 308, 311, and 312. And potentially working groups, and this may be related to biological resources, but a working group on reclamation as part of Cumulative Impacts Annual Report and CIDR. We would also ask that the commission consider a future rulemaking to update the EnviroScreen, CDPHE EnviroScreen reference to 2.0. Right now, we're using EnviroScreen 1.0, excuse me, because that's what CDPHE is using. I believe that CDPHE plans to release version 2.0 in the very near future. So we would ask that the commission conduct a very hopefully simple rulemaking to update the EnviroScreen reference to version 2.0. Also, we have a number of different AQCC references to Regulation 7 throughout, not just in the 300 series, but throughout the entire rule suite. AQCC is also intending to conduct another update to their Regulation 7 rulemaking. I believe that will happen sometime in first quarter 2025, thereabouts. And so we would ask that the commission consider at some point conducting a rulemaking to update all of our incorporation by reference to Regulation 7. Next slide, please. Future actions for staff, then we have our additional homework as well. We intend to issue policy or guidance documents to update the ALA guidance. That guidance was initially issued in late 2020 before we ever even seen our first ALA. It definitely needs to be updated, and now is a good chance to do that. We intend to create an operator guidance for the cumulative impacts analysis, both for OGDPs and for CAPs. Create new guidance for the new forms 2D and 2F, and update. Actually, I don't think that we actually released a guidance on the form 2B. I think we have a draft guidance that we never issued. So we will issue a guidance on form 2B, form 2D, and form 2F. And as mentioned in one of our previous conversations, we will issue an operator guidance to reduce the duplication of BMP lists across the OGDP application. There's a lot of new rules related to cumulative impacts that require the operator list their BMPs or describe their BMPs. Those are found in the ALA, those are found in the Form 2B, those are found in the cumulative impacts analysis. And so to try to reduce this redundancy or duplication, staff intends to issue an operator guidance that describes how an operator can create one standalone list of BMPs that can then be referenced to all of those different rule requirements. In addition, staff will be updating the Form 2B to accommodate some of the changes proposed in these rules. Minor updates to the Form 2C and or Form 2A. I'm not totally sure that we require those, but we might, so I wanted to flag for you here. And then creating the new Form 2D and the new Form 2F. The intent is to have those forms created, beta tested with the much appreciated help of some of our industry stakeholders and ready for release at the time that these rules would go into effect. Next slide, please. That's the end of the formal presentation. Next slide, please, Caitlin. I just wanted to flag that at the very end, we've got an appendix. This is the commissioners' consensus list that they shared with staff and with the public. This is just a crosswalk showing where staff responded to those directions. So just a couple of slides that will hopefully make things easier for people to see how staff answered the commission's instructions. And I think that's all I have.
Thank you very much, Ms. Trask. I really appreciate you walking through the changes at a high level. would note for everyone that the actual red lines are in the chat and in the portfolio. We've got a lot to go over. I know we're going to have some questions for you. I want to give you a bit of a break to catch your breath, to fill up your water bottle. Let's take 10. Let's return at 10:28. All right. Welcome back. It's 10:28 on Tuesday, August 8th. And we just had a presentation from staff on the red line. I've got a few substantive questions, but I'm going to just follow up with a couple of process questions real quick from you, Ms. Trask, because not all of our folks may understand guidance form versus rules and what forms are and et cetera. So if you don't mind, can you just give a quick layman's perspective so that people understand what it means when you indicate that you're going to be providing guidance versus what that is versus rules?
Yes, thank you, Chair Robbins. So the guidance is issued by staff to provide operators with practical instruction on how to meet rule requirements. And so ECMC is a forms-driven agency. We collect a lot of data through a lot of electronic forms submitted by operators. In the OGDP process, there's a requirement for a Form 2A, which is the location assessment, Form 2B, which is the cumulative impacts data, and Form 2C, which is the OGDP sort of umbrella form. Those electronic forms have data fields that have to be filled out in a very specific way for the e-forms or web forms system to work. And so we frequently issue guidance, which is not a rule. It's instruction to the operator on how to fill out those forms in a way that they can demonstrate that they are meeting the rule requirements, and also in a way that staff can review the information effectively. And so a guidance document, we've got a lot of guidance documents on our website. Admittedly, some of them are severely out of date. I think that's a separate project that a number of our staff are working on, is to update the guidance documents. So because there are new forms coming out, the 2D and the 2F, and significant revisions to the existing Form 2B, we will be issuing guidance, that instruction to operators as to how they should fill out those forms.
So thank you for that. And since this rulemaking has a lot to it involving notice and consults and disproportionately impacted communities, are guidance documents available for non-operators so they can understand too how it is that someone that wants to seek a permit can have a better shot at getting into compliance?
Yes, the guidance documents are written for operators as the primary audience of those documents, but they are publicly available and anyone can access them.
Okay, and we may need to be thinking about like how we ensure availability in other languages and availability for DI communities. On forms, a form is just that. And you mentioned we're a form-driven agency, but it's like how information is submitted to the agency, and it's an electronic form that gets filled out, and it doesn't change rules. It just uses the rule to articulate what information is necessary to make decisions. Did I capture that from a layman's perspective correctly?
Yes, that's correct. That's correct. We frequently, in the forms that we build for operators to use, let's just say the Form 2B, for example, the rule requires a number of sets of information. So how many tanks, or what is the distance to a wetland? The forms provide specific data fields. It'll say a question, what is the distance to the nearest wetland, or how many tanks do you plan to have on this location? And the operator can just enter those numbers in rather than having to tell us in an email or write it out in a paragraph. And so the forms, we develop forms to as a conduit for the operator to give us the information that is required by rule. I want to note that we also add additional data fields to forms where there is a rule that doesn't have a specific request or the rule language is a little bit broad or vague. We might add or develop 3 or 4 data fields that we need to know this to get to this to get to this. And that tells us that if the operator is in compliance with our rules. And so our forms are really, really robust. And we build them in the web forms and eForms system with business rules. And I don't mean to go down the rabbit hole, but we build them with sort of digital cross checks to make sure that information is consistent and accurate.
Great. I think these are important points for our stakeholders. A lot of our stakeholders are new to the process, so appreciate the points on those process. A couple more process questions, and then we'll open it up for substance. Ms. Stafford, Ms. Trask mentioned that we need to do some more rulemakings. We need to do a rulemaking to adopt EnviroScreen version 2.0, and we're going to later need to do a rulemaking to adopt references to Reg 7. If we know now that EnviroScreen 2.0 is going to be released in about 3 or 4 weeks, and if we know now that we need to contemplate Reg 7 and more updates, et cetera, why can't we just do that now? I happen to know the answer, but I'd like to make sure everybody understands that.
Thank you, Chair Robbins. The reason we cannot adopt something, I guess we cannot prospectively adopt a rule that has not yet been adopted by a different agency has to do with the rulemaking provisions set forth in the Colorado Administrative Procedure Act. So specifically under, I believe it's 24.4.103, 12.5, that's the incorporation by reference section, and it prohibits a state agency or it allows a state agency to incorporate by reference a rule, standard, or guideline of another agency. And so, what that means in effect is that that rule or standard needs to be in effect as of the time the commission votes to adopt it. So if we're thinking about regulation, updates to Regulation 7, updates to EnviroScreen, those updates have not yet been adopted by CDPHE. And so we cannot look to those and say, we would like to adopt those without understanding what's in that. This goes to, not just complying with the Administrative Procedure Act, but it goes to regulatory certainty. The regulated community needs to understand what rules they are being asked to comply with, specifically as they relate to rules that are from another agency that may be incorporated into our rules.
So even though we know we want to do it now, we've got to wait until those rules are promulgated, and then we look at them, and then we can adopt them then.
That is correct.
Okay. And I'm going to be speaking to the avoid, minimize, and mitigate hierarchy in a bit when I speak to the rules that I've been working on. But I heard from Ms. Trask that and we've heard from a lot of folks that the hierarchy that we should sort of flesh out, that the way we have been and intend to use it is that we do an analysis that analyzes avoid, and then analyzes when we can't avoid how we mitigate or minimize. I can't remember which one's second. And then for those that we can't mitigate or minimize and avoid, then we mitigate. And I think I heard that's going into the S statement of basis and purpose and not in the rule. Can you provide your analysis as to how that's okay and how that still helps us flesh out how we're going to be using the hierarchy, even though it's only in the SBP?
Sure. I was getting some feedback. I'm sorry there. So in thinking about making the updates as directed by the commission here, and in reviewing both the commissioner deliberation document and staff's own notes here, we were directed to provide additional clarity on the mitigation hierarchy and how that applies in the rules. And we were to determine whether the SBP or the rules themselves were the best place to land. So as part of thinking about these revisions here, staff looked back through the avoid, minimize, mitigate hierarchy discussions and SBP from the mission change rulemaking, and tried to determine, basically the best path forward from there. Based on that review, it was resolved in mission change that the SBP was the best place for this type of discussion, and staff's perspective really hasn't changed. The SBP is intended to set forth, why rules are being put into place. It is intended to expand on rule language in places where the commission would like to make, specific notes about this is how we understand things, this is how we intend for it to be implemented. And so staff felt that, again, the SBP was the best place to land this discussion. I think we had a back and forth at towards the end of deliberations where I raised some concerns related to potentially making changes to the discussion of the hierarchy that could impact the way the rules are read as a whole. It's my recollection of the edits that were previously proposed, I think, by the ALG group, that the discussion of the hierarchy and the specific rule language they were looking for was proposed for Rule 315B, the cumulative impacts analysis. And my concern is that making a change in only one spot may introduce some interpretive inconsistency elsewhere in the rules. It could introduce confusion into how we are interpreting the hierarchy and what we mean if we're being so specific in one spot, but we are leaving the rest of the discussion in the SBP. So it seems to staff that this likely requires some more substantive revisions across rule series, including those that are not noticed for this particular rulemaking. And in thinking about this and in reviewing, the best place to land this, I did review the entire set of commission's rules. We have different places in the 400 series, the 500 series, and the definitions. There are over 30 references to the avoid, minimize, and mitigate hierarchy in the rules that we would need to potentially break out in the same way to specifically set forth the hierarchy in the rules. So it's staff's recommendation, after thinking about this, since we were directed to do so, that this discussion best belongs in the SBP, much like we did in mission change, and that we would hope the commission would consider potentially overhauling the rules that speak to the hierarchy in a future, more comprehensive rulemaking. I think that is where staff has landed here, and that is where we would recommend the commission go as well.
And given where we're at in this rulemaking, and I'm going to be speaking to this issue again once I get the podium to speak about 604 and sort of the approach that I'm suggesting there. And I'm going to want to sort of see the same thing, because we had a lot of feedback from our stakeholders that the hierarchy needs to be applied there. And there was like a place where they wanted to reiterate it for every one of the criteria on my new 604. And that seemed duplicative. And so I also wanted to see it in the SBP. But if it's tucked into the SBP, are we accomplishing the goal for now, or is this a missed opportunity to put it in the rule?
I think for now, we are accomplishing the goal by having it in the SBP. For mission change, again, the discussion of the hierarchy is in the SBP. The regulated community understands how the hierarchy is to be utilized. So I think in this sense, and for this rulemaking, it fits the purposes that we need it to fit. If the commission is interested in making some more specific changes down the road, then I think that's probably something you all can revisit, and I'll defer obviously to my colleague, Mr. Davenport, on that. But again, I think the discussion in the SVP will accomplish what the commission needs to accomplish with the mitigation hierarchy, which is to clearly articulate how it is to be applied and how the commission intends it to be applied.
Okay, great. Thank you very much. I have another substantive area, but I want to open it up to commissioners so that everyone has a chance to ask questions of staff. So looking for hands raising and other folks. Commissioner Messner?
I'm happy to go down the mitigation hierarchy topic here a little further. So acknowledging that it's in 3 different places in the statement of basis and purpose right now after mission change rulemaking. You know, it's in the wildlife section in the 1200 series, it's in other sections in the 300 series and the 500 series, but I think where I'm struggling with this is the current rules, as well as the draft rules, don't equitably utilize the same terms throughout the rules. And so sometimes you see avoid, minimize, or mitigate, which to me would indicate they could pick one of those things to accomplish the rule. Sometimes it says avoid, minimize, and mitigate. Sometimes it says minimize adverse impacts. That goes back to the definition of minimize adverse impacts, which also brings in the definition of unavoidable adverse impacts, minimization of adverse impacts, mitigation of adverse impacts. And so it's this crosswalk that you can certainly do, and I'm certainly comfortable with it. And I quoted the statement of basis and purpose in many OGDP reviews and, you know, imploring that the mitigation hierarchy get employed properly by operators. But I still am struggling because it's already in the rules, in the statement of basis and purpose, in the definitions, and how it gets crosswalked, why it wouldn't be possible to refine the language in areas of the existing rules that were, or the rules that we're contemplating now, to better clarify the desegregation and walkthrough of the mitigation hierarchy, which is already required anytime the term minimize adverse impact is utilized, because it refers to that in the definition. And so why not make it clearer so that commissioners, when they're doing their review, have better clarity on how we apply it without having to crosswalk 100 and some pages of a statement of basis and purpose to get clarity on the mitigation hierarchy, for operators to better understand how they can walk through it in their applications to make a clearer application and have a more efficient review process of applications, and for stakeholders in the general public to also clearly understand what the operator is proposing, because I certainly don't see that in applications being developed in that desegregated avoid first, then minimize in areas that it's not avoidable, and then apply mitigation to those things that are not avoided and mitigated. And so I'm struggling to see a little bit the pushback on trying to make clearer rules rather than have to walk through, relatively complicated crosswalk of definitions and intent in the statement of basis and purpose.
Ms. Stafford?
Thank you, Chair Robbins. And I think we may be looking at this from 2 separate viewpoints here. I think the change that is being suggested here, while it will clarify one particular rule, it will introduce confusion into the rest of the rules, because if they're, especially with those rules that are not part of this rulemaking, if we can't make that comprehensive update to ensure that all of these rules reflect the mitigation hierarchy in the same way, then that would seem to me to be something that update. I'm concerned that, again, go here in front of us. Oh, can you hear me? I just
You're
get an
starting-
unstable.
Yeah, you're starting to freeze up a bit. You might want to drop your video and maybe that'll help out.
Sure. Apologies for that. So I think, again, from staff's viewpoint, making the change sort of for one bucket, but not applying it across all series here has the potential to introduce confusion. And that's where we're coming from here with the pushback. We would prefer that it be a fuller, comprehensive delineation. And because of the way that this rulemaking was noticed, it seems like that might be something for a particular rulemaking on that subject.
Okay, well, I appreciate your perspective. I'm not sure I agree. Only because, I mean, I'm not trying to like push something that's inappropriate, but the mitigation hierarchy is already built into the existing rules. And so this is actually just providing better clarity in the rules that we have noticed. And so I guess I'm just not following the rationale, but that's okay. Appreciate your opinion.
One other question. This is again a process question, and then Commissioner Ackland, I'll call on you for substance. We're talking a little bit about the statement of basis and purpose, and that's the sort of document for everybody else's edification that sort of provides clarification about what our rules mean. And we've not seen a revised SBP at this point, and that's because we're waiting to sort of see where we land on the substance of the rules, and or that's also because of just sheer volume of work. And it could be both of those reasons. Am I right? Or can you correct me there, Ms. Trask?
Yes, that's correct. I would defer to Caitlin on this, to Ms. Stafford on this. She has been a lot more instrumental in updating the SBP than I have.
Anything, Ms. Stafford, on that question?
Thank you, Chair Robbins. I think you articulated the reasoning there. It's a bit of both worlds there. Just the sheer volume of the rule updates we need to make, and also there are, these revisions reflect the commissioner's initial deliberations. So as we are incorporating things into the SBP and making those updates, this will ultimately serve as the reasoning for why these particular rules were adopted, and we want to ensure that we are reflecting that correctly. So we are trying to take our time with that and ensure that we're reflecting where the commission ultimately lands on these revisions.
Okay, thanks for that. I think that helps clarify. Commissioner Oath?
Thanks, Mr. Chair. Just a quick follow-up suggestion or thought on that. I appreciate that process component overall. On this issue, I am wondering when we get to a point of kind of talking through as a commission which direction to go here, whether we do want to see a change in rule versus whether we think that kind of this goal of providing additional clarity can be accomplished in the statement of basis and purpose. It may be helpful to be able to see what it would look like. And I don't want to send staff down a writing exercise if we don't go that direction, but putting it out there as an idea that, at least for me, I might find that helpful to determine whether or not would really think we need to put in a rule whether we can accomplish the goal in the statement of basis.
And just for clarification, from my perspective on rulemakings, when the statement and basis and purpose is a document that just sort of clarifies, sort of unanimous direction on where we're going, I've not, and I don't believe we've felt a need to kind of see the language before it's developed. But in the instance that we're talking about here, where the SBP is going to be utilized as a vehicle for an important component, and we want to make sure that we're comfortable with the use of that vehicle, that might be a change in which we want to see the language and compare it to what we might think about it as a rule. I think that's what you were kind of saying, Commissioner Oath. And if that is what you were saying, I agree wholeheartedly. So thanks for the affirmation there. Commissioner Ackerman?
Thank you, Mr. Chair. I think that comment addressed at least one component of the line I was going to explore, but I hadn't considered a potential future rulemaking associated specifically with the mitigation hierarchy. Reason I hadn't is because I think we pretty well understand the mitigation hierarchy, how we want to implement it. And so I guess my question is to AAG Stafford, that if we were to have a future rulemaking on the mitigation hierarchy, can you talk a little bit about what you think the scope of that rulemaking would be? Would it just be clarification of those rules? And if so, I agree with Commissioner Messner that maybe approaching them sooner rather than later in this rulemaking might be a good idea. If we're talking about a larger scope rulemaking, I'd be interested in that discussion.
AAG Stafford?
Thank you, Commissioner Ackerman. I think my suggestion was more that because the mitigation hierarchy touches so many different rules in different rule series, that to fully incorporate those specific edits across our entire rule set could potentially require a more comprehensive rulemaking to do that.
Thanks. And so I don't want to put words in your mouth here, but what I'm inferring is that you're not necessarily suggesting that we have a detailed broadening or discussion about changing the mitigation hierarchy or how we implement it, but you do have some concerns about the complexity of modifying all of those rules and the time that it would take and the effort that it would take and the potential implications. Am I inferring correctly?
Yes, I think it would be a much larger project than we could potentially accomplish here.
Thanks, I appreciate that.
Other questions from commissioners for staff? Commissioner Messner?
I got a few questions on other topics. So I think I lost it a little bit in the suggested timing changes to Rule 304B2C, Roman at 3BB, and how that ties into 304B7J. I think I'm not following. So I just wanted to make sure I'm following.
Ms. Trask?
Commissioner Messner, are you talking about in the ALA, the requirement for the data table? Sorry, I'm looking at the rule reference.
Yeah, because there was one that had a data table, and I thought that was and maybe I'm writing things down wrong too, but I thought that was the one that you had suggested that you wanted to change the distance.
Yeah.
And then 304B7J has a mile, and I think there was some rationalization that maybe you can just walk me through the whole thing.
Okay, I think I understand where you're coming from. In 304B2C, that's contents of an alternative location analysis. And then in that C, under subpart Romanet 3, talks about a data table for the proposed oil and gas location. And then under Romanet 3, there's little bb, which says for proposed oil and gas locations with a working pad surface within or within 1 mile of a disproportionately impacted community, then the next 3 subparts have to be included in the ALA. This is completely separate from the disproportionately impacted community map.
But wasn't that 304B2C? Isn't that the one that you wanted to contract, or am I writing that down?
Yeah, no, you're correct. You're correct. That's the one I wanted to contract. The current rule, this is a current rule that's in effect now, that for proposed oil and gas locations with a working pad surface within or within 2,000 feet of a disproportionately impacted community. That's the current rule. the draft that came out this morning says within 1 mile of a disproportionately impacted community. And my hesitation, my desire to change this back to 2,000 feet is that it's not contemplating proximity to people. It's only contemplating proximity to the boundary of a disproportionately impacted community. And so I don't know that requiring the additional information would, for a location that's a mile away from a DI community, would add any real value to the application.
I get what you're saying. I think where I'm maybe struggling with it, and maybe you could help me with the language a little bit. And I think it's just a language thing. As I look at it, it says, and I understand intent, and so I don't disagree with you that the 2,000 feet, if the intent is, if a proposed oil and gas location is anywhere within a disproportionately impacted community or within 2,000 feet outside of a disproportionately impacted community, then that's what it should say. And I agree with that. It could be read a little bit as saying 2,000 feet, a working pad surface within 2,000 feet. I guess with that 2,000 feet, a lot of people are going to like 2,000 feet of an RBU. And I know it doesn't say that, but I think that's where a lot of people were going with that one. And so I don't know if there's language that can change there that would distinguish it a little bit from 2,000 feet within an RBU or not. So I think that's where some people were maybe concerned on that one. And so I understand intent.
I agree with you. I think that we could probably come up with some clearer language. This one's been a little bit frustrating in our current rules, and so I think it would be nice for us to take an opportunity now to clarify it better. I don't have suggested language off the top of my head. This is something that I actually sort of stumbled upon late last night as I was putting these slides together. And so if given an opportunity to fix it, I would like to be able to provide some revised suggested language if that's helpful.
That'd be great. And I understand intent, so I appreciate that. I did also want to just clarify, I think in your slide, one of your slides, you indicated that 314F had a distance out to a mile, but in the rule, it goes out to 4,000 feet, at least the draft that came out this morning. And I didn't know whether you wanted it to be a mile or maybe it was just a typo, but I wanted to just clarify that. Again, I could be writing things down wrong too. I'm trying to keep up, but.
Were you referring to the slide sort of near the end where there's a summary of the distance radii?
No, it's when you were walking through the 300 series rules. So I noticed at the end, it also had it back at 4,000 feet. So I just trying to figure out which one you want.
I'm not totally sure which rule you're referencing.
So it's 314F. And I think you mean it to be 4,000 feet, but I just want to make sure as we're going through this, because this is our chance to go through it and look at it, that you wanted it to be a mile or 4,000 feet.
I see, yeah. The rule 314F1, the public review process for CAPS,
Right.
Changes the notice of completeness determination to be sent to all RBUs within half mile of proposed locations, or all RBUs within 1 mile of the proposed locations for DI community RBUs.
Okay. And I just want to cross-reference that in the draft rules to make sure. And again, I'm trying to go as fast as I can here, and I'm sure I'm missing stuff, but I thought I read in the draft rules that it said 4,000 feet, but maybe I'm missing it.
No, I think you're I think you might be right. I think in my other slide, on slide 34, I have 4,000 feet. So I need to recall what we put in the rule. I'm not sure that I remember off the top of my head what that distance was meant to be.
If I may, I'm sorry again about my video. Are we looking at Rule 314 F1C Romanet 6?
So I have it written down in my notes as just 314 F1, and so I'm scrambling here as fast as I can to get to the rule so that I can be. And in the rule it says 4,000 feet. In the slide it says 1 mile. I'm just trying to figure out which one it is as far as what you are thinking would be the best of that.
Commissioner Messner, I think I had I think I mistyped it in my slide. I believe 314 F1C, it's 4,000 feet.
Okay. Okay, that's all I mean, I was just trying to clarify there. And then this one's gonna be a little more complicated, but I'm contemplating feedback that we've got from stakeholders around application of substantial equivalency. And I know that Chair Robbins is going to talk about this, but before we get to that, I wonder if you could talk a little bit about how you currently review siting of oil and gas locations within 2,000 feet of homes in a CAP application that includes preliminary siting, and how that gets reviewed currently, because I think that may aid us in further discussion about 604 later on today.
Yeah, thank you for the question, Commissioner. I want to make sure I understand it. Are you asking how staff currently reviews proposed locations in a CAP where the operator is seeking preliminary siting approval?
With RVUs inside 2,000 feet.
Okay. We basically review those the same as we would review them in an OGDP. So the rule requires that an ALA is submitted. So the ALA will have all of the requirements laid out in the Rule 304 B2B, the ALA rules. It also requires that the operator submits a handful of different maps and figures in Rule 304. I want to say it's a location drawing, it's a facility layout drawing, construction drawings, a list of the equipment used. And so staff reviews all of that information the same as staff would review it if it were just a regular OGDP. And so when the location has RBUs within 2,000 feet, we specifically look at all of the requirements for the operator to demonstrate compliance with all of those rules. I don't foresee that there would be any difference in review. The information required with the CAP is the same information that would be required for the OGDP. The director does have the ability to request additional information if needed. So in a CAP for PSA, we do get the standard suite of information that the current rules already require. If we needed additional information specific to those RBUs within 2,000 feet, we could request that. I would think that that information is already being provided, but we could request additional information if needed.
Okay, thank you. Those are the only questions I have.
Commissioner Ackerman?
Thank you, Mr. Chair. And I have a couple of questions just about the draft regulations, and some of those might just be clarifications of the red line. Happy to go through those now, or if you think there's another time that we're appropriately going to walk through the red line, I'm happy to wait till then.
I think going ahead and asking questions now probably makes sense. I think we still haven't like figured out what next steps are going to be, but why don't we go ahead and continue the dialogue at this point, and then we'll see what our next step is going to be.
All right, thank you. I have four primary questions, and the first one's associated with the community liaisons, which starts on page 4 of the draft rules. And we had talked about this during the hearing. I'm in 224C3, and it currently reads reviewing community. This is a duty of the community liaison. It currently reads reviewing community outreach plans submitted pursuant to Rule 304, blah, 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 and providing feedback to the director and non-legal comments to disproportionately impacted community members. And I know we had the discussion about, are those two separate commenting mechanisms or responsibilities by the community liaison? Are we intending for them to kind of put together a report that can be disseminated to members of the community as well as the director? Can you give your thoughts on kind of where you think we ought to be headed there?
Mr. Ask?
Sure. Thank you for the question, Commissioner Ackerman. The way that I would envision this provision of the rule is that the community liaison will provide feedback to the director throughout the permitting review process. And then the director would incorporate that feedback in her written director's recommendation on that OGDP. I think that the community liaison will be hopefully working very closely with members of the DI communities near that location, such that if the community liaison had concerns about information that is provided in the community outreach plan, whether it's a lack of information or information that is concerning, I would think that the community liaison would flag that for the location assessment staff and the operator, and start by asking the operator for clarification. Is it a typo? Did you mean to say this? Is this something you want to revise, redo? And then if no resolution comes of that communication, then the community liaison would be able to provide sort of their flag for the community members directly and say, this is what the community outreach plan says. This is maybe something that you as a community would like to discuss with the operator. I don't think that the community liaison should tell community members what to do about concerns. I think they should facilitate community members having conversations with the operator as appropriate, and really facilitating that engagement between the operator and the community members.
Thank you. That's helpful. So I'm boiling down to that's probably two different lines of communication and appropriate as written. Two other questions on the community liaison. One of the things that they're intending to provide to the director, it says this is in number 11, to provide the perspectives of the disproportionately impacted community members regarding the operations proposed. And I know we had significant discussion about perspective and different words, and I thought we had landed more along the lines of specifying that it's feedback instead of trying to interpret the perspectives of the DIC. Can you talk a little bit about why staff landed on the word of perspective there?
If possible, I might ask AAG staffer to jump in and help me on this one.
Sure, I can certainly do that. So in our review of the initial deliberation summary, it's on page 2. There is specific direction to replace subpart C11 with specific language around providing the written consultation to the director. And the word perspectives is found in that language that we were directed to incorporate. And so that's why we did it that way.
Thank you, AAG Stafford. I appreciate that. The last question would be on letter D, independent positions, and it currently reads, neither the commission nor the director may direct the community liaison to take any specific position, which makes a lot of sense. But did you ponder instead just stating that the community liaison may not take a specific position on issues? And implicitly, that would certainly include they can't be directed to do so. I just think it leaves that a little ambiguous that they may be able to take independent positions if they're not directed by the commissioner or the director to do so.
Commissioner, I think that's a good catch. I think our intent is that the community liaison wouldn't take a specific position based on anyone's direction. So maybe that is language that we could revise to make more clear.
Thanks so much. My next question is on page 18 under director's recommendation. And this is in Rule 306, 306B3 under denial. This is obviously where the director can recommend denial, and it states about halfway down, one of the provisions is or shows that the operator has demonstrated an inability to comply with its NOx intensity or greenhouse gas intensity, whereas other references, rather than saying demonstrated an inability, they say have not demonstrated an ability. And I think that's a nuance, but it shifts the burden to some degree. If they can just show that they've demonstrated, if we have to show that they've demonstrated an inability, that's more on the director to demonstrate that. And rather, I think the intent is for them to demonstrate an ability to comply. And that would line up with 307, the commission denial language as well. And so that was just an anomaly that I found in there and wanted to see if we needed to fix that or if it was purposeful language.
That's another good catch, Commissioner Ackerman. I think that that was not the intent, and I think that's something we can readily change to be in alignment with the rest of the instances of this, where the operator would demonstrate their ability to comply.
Thank you so much. And then just a few more, and I appreciate your indulgence here and that of my fellow commissioners. On Rule 315, that's the cumulative impacts data and analysis, and this is on page 44. And I'm down under 315B2A. And so that's towards the bottom of page 44 and all of the red line language there. And towards the very bottom of that red line language, we talk about contracted areas of evaluation. And throughout that section, we say the operator may utilize areas of evaluation smaller than the areas of evaluation in the reference rule. And then it preserves an opportunity for the director to evaluate that utilization. It just makes more sense to me to change those references to the operator may propose areas of evaluation. I think that more accurately helps them understand that these are subject to director review. And so then that would require some changes at the bottom of page 44 and then at the top of page 45. And again, I open to any discussion if utilize was used intentionally.
It was not. I think that I prefer your suggested use of the operator may propose smaller areas of evaluation.
Okay, thanks. One more language suggestion and then one more general question. And the final language suggestion is on page 65. This is in Rule 904, evaluating cumulative impacts. And I certainly appreciate the inclusions of staff here. And I'm looking at 904A1B, the new inclusion of reclamation in cumulative impacts analysis. And it currently reads information regarding reclamation during the prior year, which is good because then it, that's pretty broad. It can include a lot of language. And then it specifies including wells and locations that achieved final reclamation, which again is an important data point. I do think it would be of benefit to add to the end of that sentence and the status of pending reclamation work. I think that that's what we're trying to get at as well, as understand what the reclamation landscape looks like out there. And so I think another broad clause at the end of that would help us be able to report percentages, status of individual projects, or at least status groups, and give us more of an opportunity to be inclusive about reclamation reporting.
I appreciate that addition, and I think that that gives us yet another chance to work closely with our reclamation staff in figuring out how most effectively and efficiently to produce that data.
Thanks so much. And then I'll have some comments about the statement of basis and purpose in deliberations as well on this item. The final question I have is not necessarily associated with a particular regulation, but we heard during the hearings and we've heard in some comments about water quantity. We've talked a lot about water quality and implemented some appropriate draft regulations, in my opinion, on water quality. And this might be more a question for the Attorney General's office, or maybe even for Commissioner Messner. We've got an upcoming produced water rulemaking, and certainly a major component of that will be discussing the water that's being used in oil and gas operations. If during that rulemaking, will we have an opportunity to address water quantity in a cumulative impacts perspective as well as part of that rulemaking, or do we need to kind of predetermine some cumulative impact rules associated with water quantity? And just wanted to see if staff has pondered that idea, or if Commissioner Messner has any thoughts as well.
Staff?
Commissioner Ackman, we are collecting some limited data about water quantity in the Form 2B and the upcoming Form 2F. Some of it is geared toward establishing or understanding what is the volume of storage, tank volumes on locations storing for long-term storage of hydrocarbons, of produced water, with the intent that if there is some sort of failure on the location, how much potential fluid could be spilled or travel off the location. So we do capture that water quantity data. We also capture in the Form 2B some preliminary estimates on water use, how much water is anticipated to be used for drilling and completions operations. So, and we have a further breakdown of how much of it is fresh water, how much of it is recycled produced water, where it's fresh water, how much of it is from a surface source, how much of it is groundwater source. So I would be curious what, if you have other ideas about water quantity data that you'd like to see us gathering. Because I do think that where it is specific to cumulative impacts, this would be an opportune time for us to capture that.
Yeah, thank you. The only point that was missing there, I think, is the quantity of water permanently injected pursuant to oil and gas usage. I don't know if we collect that data, but it would certainly be of some value. And it looks like Commissioner Messner also has some thoughts.
Commissioner Messner?
Yeah, this is a good question, Commissioner Ackerman. So there, as of this year, end of last year, this year, HB 23-1242 did direct the commission to collect a number of different data points around water quantity on different Form 7s, another Form 42, I think. Well, it might be a Form 47. I can't remember all the form numbers now. But we are collecting overall water quantity that is being used on a per well basis, monthly, on a per location basis, quarterly. That includes both fresh and produced water. They are required to provide information on how much reused or recycled produced water is happening at each location. And so there's a lot of data that's being collected just recently. So really in the last year, that's starting to build that information on total fresh water that's being utilized, how it's being utilized, where that water is coming from, and then how much is reused and recycled of the produced water. And then collected information on disposal, like if it's not being recycled, what the end result of that is. And so I'm not explaining this very well right now, but I think a lot of that information is captured. But I think the root of your question, and I think is an important one, is whether or not should we decide that there needs to be additional information or perhaps analysis that needs to happen on cumulative impacts to water quantity in a cumulative impacts analysis, whether that addition, should we deem it appropriate, could happen in the produced water rulemaking, or whether it needs to happen in this rulemaking where it's noticed as a cumulative impacts, like that rule series is noticed. And I don't know the answer to that. I don't know if the rule series, like the 300 rule series, was noticed in the produced water rulemaking that would enable us to have that conversation during the produced water rulemaking.
Thanks, Commissioner Messner, and I appreciate your explanation there. And yeah, you hit it right on the head there. And it slipped my mind that we've already noticed that, and so maybe the Attorney General's office can help us understand if 315 would be included in that rulemaking, or if there would be opportunities to include it, as that was going to be my suggestion. I don't know if Ms. Stafford is still with us, or
Ms. Stafford, it's hard to tell when she's not visualized. Mr.
Apologies. I do not have the notice in front of me. I'm wondering if my colleague, Mr. Davenport, has that
Mr.
particular
Thomas,
notice.
we have it.
The 300 series was noticed for the produced water rulemaking.
That's wonderful. Thank you. And so to me, it certainly makes some sense as we're talking about the produced water issues that we keep an eye on whether there might be some cumulative impacts there of that rulemaking. Thanks for the discussion. That's all that I have, Mr. Chair.
Other questions for staff? Commissioner Oath?
Thank you. I have questions on, I think, just two areas. The first one, Commissioner Ackerman referenced earlier, kind of around the community liaison and their role in weighing in on the community outreach plans. So as I had been thinking about this, and I recall us having some conversation during the hearing about how the draft rule contemplates the liaison providing feedback to the director as well as to community members, but doesn't say anything with respect to the operator. And we talked about how, in general, it would be good practice for operators to consult with the community liaison and get input on a plan. That said, I don't want to overburden the liaison, knowing that there may be quite a number of these outreach plans, and so trying to thread the needle there. One thing I know we did talk about it, and it may have, and totally understandable, it may have gotten lost, or I may be missing it. But one piece we did talk about was how we could utilize the community liaison as a resource for operators to identify whether or not there's a community-based organization in the area. And if so, to develop the community outreach plan with recognition of partnering with that organization in terms of how to do the outreach and how to get notice out to community members. And so we included similar language to this in the geothermal rules. So I can read that in general to explain where I'm going. And I think this goes into 304C19. And it would be something along the lines of saying, in developing the community outreach plan, the applicant will consult with the Commission's community liaison to identify local community organizations representative of the potentially impacted communities. If the community liaison identifies such local community organizations, the applicant will coordinate with such organizations to distribute necessary and relevant notice and information to the community. I just think it's a good practice and a way to get information out to community members in the most effective way possible. So I guess it's not a question, but if you have it, if I missed it and it is somewhere else, then would want to hear that. But otherwise, I would love to see that.
I don't think that we have that or something specific or similar to that in this draft. I am not familiar with the not as familiar with the geothermal rules, but I'm happy to take a look at those and see how it makes sense to incorporate that concept into 304 C19.
Thank you. And then my other questions are in 316. So there's a couple of kind of discrete language things here. So bear with me. So the first one is in 316A. Nope. 316B, excuse me. 1B I, and then there's 2A's, 2B's, 2C's. And so this is saying the operators, okay, for Form 2Ds submitted kind of after the first year, the operator is going to submit their intensity information, which is going to include, and then the AA is their most recent annual report, BB is their interim report, and CC is or a statement certifying that the operator is not subject to the NOx intensity target. This is probably a question for Ms. Stafford. I think that we have to combine AA and BB because of the way that the ands and the ors work there. So if you want to, that would be my suggestion. Otherwise, I think it's saying they have to submit the annual report and then either the interim report or a statement saying they're not subject to it, and that's not what we mean.
Thanks, Commissioner Oath. I can understand the way that you're reading it. I read it a little bit differently, but I agree that a change is probably appropriate there to make sure that we're being totally clear about what we're asking for.
Thank you. Okay, going down to the next page. So this is language I think that you had indicated, Ms. Trask, it was largely taken from Oxy's proposed exhibits, which I think is consistent with what we talked about in deliberations. There were some wills that I think you've changed to may. So I wanted to understand kind of the thinking there. In general, I will say I know we talked about wanting to continue to allow for a lot of discretion for the director and the commission in these circumstances, and I continue to think that's appropriate. I did think that there were the two circumstances here where it may make sense to keep the will, and so this is in 3A little I. This is where we're talking about that if they're overly compliant, right? So if they've met that 20% more or greater, I think the intent of this construct of having that is that that's sort of a kind of automatic pathway to approval instead of the closer look. And so I think that I had been thinking, or I know it was proposed to be the will there, but this draft's got a may. So if you've got, if that was intentional and you have thoughts, would love to hear kind of what the thinking was there.
Commissioner Oath, I can chime in here. I think at least in drafting, while you are correct, we did incorporate a lot of the proposed language from Oxy. I had also heard discussions about just overall in Rule 16 or 316, excuse me, just ensuring that the director had discretion when it came to approvals of forms. So, I could have misinterpreted that as applying to this particular area. So if it is your and the commission's intent that may should be a will, I think we can make that change. But that's a little bit of, I guess, the background and how it currently exists the way that it does.
That makes absolute sense, Ms. Stafford, and apologies on my behalf for the confusion there, and appreciate you and your clear intent to try to carry out our directive. But for me, yes, in that section, I would want to see a will, and then there's one more where that would be the case for at least for me. So it's a little bit further down, and so that's in subsection 2 in the BB. And so this is okay, they haven't been overly compliant, so they either have been not in compliance or they just don't have a big enough buffer, then we're going to take the closer look. And so they, look at they're providing some additional information to the director's taking a look at it. And then in BB, we say, if the director believes that, those additional activities demonstrate that the operator can comply with the NOx intensity target, then the director, and then the draft says may approve. But I think to me, they've made that demonstration. That's exactly, then that should be a will. So again, I'm guessing that you were kind of going from the same target in terms of changing that one from a will to a may, but I would personally want to go back to the will for that one.
Thank you, Commissioner Oath. Yep, that one suffered from the same misunderstanding. So I think we can make that change if that's what everyone wants.
Thank you. And then, okay, on the following page, so now we're in 3, capital B, production operations within the ozone non-attainment area. If the director determines that the information on the 2D indicates that the operator has exceeded or is unable to comply with its NOx intensity target, then the process set forth in 316D will apply. I had flagged the has exceeded because I thought that was new, but now that I'm looking at it, it makes sense. So I may need to scratch that question. Never mind. My apologies. And then I think the last question, Ms. Trask, I think you addressed this, but I just want to make sure I'm really clear about this. In D1, you had, I think you addressed in your presentation that here we're in, situations where an operator has not complied with their NOx intensity targets. And I think you addressed that in this case, you put may require such additional actions such as, prohibition on pre-production operations, more ESPs, other actions, those types of things. And that it was intentional to keep that as a may instead of a, will impose additional actions. And I think what I understood you saying is it's not really that you intend that only sometimes the director will require additional actions in that situation. It's just to account for situations that we can't even imagine right now. And so but the intent would be in all situations that we can imagine in this moment, that is what the director would be moving towards. And it was really just to capture that unknown. Is that right?
Yes, Commissioner, that's correct. I do see that we probably have some room to improve this language to indicate that the director will assess additional actions or require additional actions, but those actions are not fully itemized in this list. So that's a clarification that the commission would like. I definitely see that we have room to do that.
And Commissioner Oath, if I could,
Yeah.
I plan on speaking to this when I get into some of the things that I'm doing that wasn't necessarily right on target, but it became part and parcel of the discussion. So just if you want to put a pin in it, I've got some thoughts on that as well.
That sounds good. I think that's all I have. Thank you.
Commissioner Messner?
Thanks. Maybe I ask a question because, I do have a number of red lines, as I think everyone does, of mostly little things and some more substantial things. Do we intend to go through and kind of talk through kind of page by page or section by section and have some deliberation so that we can determine whether there's consensus on certain things or not, or how, from a process standpoint, I'm just curious how that goes. Otherwise, I can walk through some of these with staff, but then that's just me expressing my thoughts, but I don't know where any of the other commissioners land on it.
Yeah, Commissioner Messner, good question. I was trying to allow commissioners substantive questions to staff on the slides, which is tangentially on the red line. What I thought after we exhausted those questions, I would probably try to go through the work product that had been assigned to me, which I've continued to work with stakeholders on, and walk through kind of where I land and then see if commissioners are in agreement with that. I also wanted to give commissioners, I don't know if this is the case, but if any commissioner wanted to put, anything new or different on the table, because that's kind of what I'm going to be doing, that opportunity should present itself. I then wondered to myself, does it make sense to take a bit of a break, maybe over lunch or maybe over lunch plus an hour, to give commissioners a chance to go over their notes and the slideshow and the work product that I'm going to present to you, and then come back, mid-afternoon or early afternoon, I don't know what, and then try to answer that question. I don't know that, at least where I stand right now as one commissioner, I need to walk through every line by line or every page by page to get to a comfort level on where I think we need to be. I would like to provide the opportunity for commissioners such as yourself to, show us the places that you've got nits or picks, or if we've got major substantive issues, we certainly should dive into that. But that's my thought approach on the next couple of hours that we have ahead of us. But I want to hear from other commissioners in terms of a process.
That works for me. I think I have a couple of more substantive pieces that actually I would like staff feedback on, but I don't know if I don't want to necessarily get staff feedback on it right now until I present it to the commission, other commissioners, and see if it's even worth, contemplating. And so can I assume that staff would be available should commissioners have questions or want to get feedback from staff on particular topics later on in the process, rather than throwing it out here now, or I can throw it out here now, whichever.
I mean, if you're comfortable with it and if the commissioner's okay with it, why don't you hold that for now? And then when we come back after a break, we could probably, it might be wise, and we're sort of making this up as we go, to sort of like allow commissioners to raise something other than nits and picks and language things, substantive issues. And then if substantive issue X is raised by Commissioner Y, we can see if we've got consensus that that issue is broken and needs to be fixed, or it's not broken and doesn't need to be fixed. And then we can move to the next substantive issue. And then once they're through with those, we can allow commissioners to target in on, specific language, some of which Commissioner Ackerman did this morning. Any other procedural thoughts? All right, well, let's give 5. Let's return at 11:46. I'll go over, it'll make maybe 10 minutes, 15 minutes to go over some of the things that I've been working on, get that out there, and then we can take a break for an hour or two, and then come back this afternoon and, really dive into the final pieces of substance. Let me say one more thing before we take our break. And so I retract the break to 11:46. Depending upon where this goes, another question that we have for ourselves is, do commissioners believe there is a need for additional public input, stakeholder input, et cetera, into the draft that we've developed? And I'll provide some initial thoughts on that idea. And we don't have to answer this question right now, but I believe we have allowed for a thoroughly thoughtful process with a lot of input from our stakeholders into the work that we're doing. I think our rules have adjusted and have been influenced and have gotten much better as we've gone through this huge undertaking. And I believe we're at a place where the subject matter experts that are the commissioners here with our staff are at a place where I think we can make some decisions for the state of Colorado, and then, move on into the realm of having a cumulative impacts and a disproportionately impacted community and enhanced systems and practices regime and start letting it play out. That's me. Are there other commissioners that are in a different camp where they would like to see more feedback to either the red line we've got now or other things that are out there. All right, I'm not seeing anybody raising hands, so maybe we can tentatively approach it that way, that after we're done with our break, we'll come back and we'll start deliberating a bit over big issues and then small issues and just see where we end up by the end of the day, knowing that we've got next Tuesday set aside as well. So with that, let's return at 11:50, and I'll take 15 minutes or so, and then we can take a break, a longer break for lunch. Okay, welcome back. This is the Energy and Carbon Management Commission. It is October 8th. It is 11:51, and we are continuing in docket 2406-00145, the Cumulative Impacts and Enhanced Systems and Practices Rulemaking. In a bit, I'm going to share a screen, waiting for all commissioners to be able to get back before us here real quick. Welcome back. We are going to proceed with the Cumulative Impacts and Enhanced Systems and Practices Rulemaking. I had a few points I wanted to make. I've shared some additional red line edits with commissioners. I've also shared a document that I conveniently called an explainer document. It just sort of explains the work that has happened on these two proposals over the last week or so. I was assigned the ideas of disproportionately impacted community protections, setback, and the NOx issues, or at least some of them. And I wanted to thank all the parties for having discussions and further feedback on these important issues. And with that, I guess I would start out by saying that the Rule 604 that was drafted and the Rule 316C that was drafted remain largely intact. I do have some suggested proposed edits that I would like to propose to my fellow commissioners. With that, I will see if I can accomplish something that I normally cannot, which is sharing a screen. Give me just a sec. Oh, I did practice this. All right. Can commissioners let me know if they can see the document?
Yeah, Mr. Chair, we can see the explainer document.
Okay, good. That's where I wanted to start. And actually, thanks for saying that, Commissioner Oath, because I wanted to segue off of the places that you were going previously. So I've had a lot of discussions with a lot of different folks, and one additional edit to 316, and I've made some edits to 316 C, and this is an edit to 316D, and it actually, Commissioner Oath, gets to where you were wondering about or pondering, which is the fact that right now that indicated the director may require the operator to take actions if the operator is out of compliance with the NOx intensity targets. And I believe that the appropriate move here is to actually move that to a, move it away from may and move it into will. And will is the same as shall. but under our AAG's analysis and verbiage, they use the word will. I would note that what that means is that even so, that's basically saying that if the director finds that the operator, be it a drilling operator or a just producing operator, is out of compliance, that the operator will undertake actions necessary to assure compliance with the operator's NOx intensity targets. Those actions are then illustrated in the two sub-bullets below it, which are not on this page, but they're in the actual rule. There's 4 sub-bullets for drilling operators and a few or pre-production operators, and there's a couple more sub-bullets for producing operators. There is also the discretion to the operator to the director in terms of what the action item ought to be. But I think it is appropriate and a proper place to end up that this is one of those areas where if they're out of compliance, there is a will, the director will do something and the operator will comply. So that's the first sort of first and one of the larger suggestions that I'm going to make this morning in terms of trying to, and this is the one dealing with NOx intensity. So moving down the path, actually, before I move, AAG Davenport, can you visualize yourself and speak just a little bit to what we might find in the SBP around this line, assuming the commissioners decide to go there?
Thank you, Chair. I think it, excuse me, may be appropriate in regard to this may to will to still recognize or highlight within the SBP that the commission still does intend to provide the director with significant discretion on what actions may be necessary. I would note not only, though, that the rule itself in the rest of the language does suggest certain actions, but still allows the director to take whatever action may be appropriate. And so given that this may to will challenge does require the director to take actions, I think it's appropriate to note that the commission's intent is still to provide the director with significant discretion on what actions to take.
Great. Thank you, Kyle. And let's continue to tag team as I work through this document. So the rest of these are, I felt like that was one of the more important ones, so I put it first. The rest of these are not necessarily in an importance caveat, but they're all important to getting the proposals to the right space. So the next one had to do with substantial equivalent setback for DIC issues. And so we're working off of the 604 setbacks and siting requirements that I daylighted about a week and a half ago. The first issue here is the level of work to get informed consent sign-offs. Some parties wanted to see a best effort standard, and other parties were comfortable that a good faith effort standard made sense. AAG Davenport and I worked on this, and we came up with sort of a middle ground of all reasonable efforts in terms of the informed consent sign-offs. The all reasonable efforts, I think, makes a lot of sense. Efforts that are reasonable ought to always be undertaken. Efforts that are not reasonable ought not necessarily to be undertaken. And so I think that's a good landing spot for this issue. And the red lines that have been shared to the world as well as to you commissioners in your inbox have all of this in the red lines. This is just illustrative of the proposed changes. Another important topic that has had a lot of discussion is that we have continued to keep 604B A off-ramps 1 through 3. That is the informed consent off-ramp, the comprehensive plan off-ramp, and the moving the emitters off-ramp away from 2,000 feet as off-ramps to when someone wants to drill within 2,000 feet of an RBU and a DIC. Some parties desired that this be removed, while our other parties required continued application of this provision. I suggest we keep it in the setback. We really want to continue to incentivize comprehensive area plans. And I think as we move forward with the potential for evaluating comprehensive area plans, the commission will know in the back of its mind that as it's looking at a comprehensive area plan, and if there's a potential for something within 2,000 feet of an RBU, we will ensure that it is protective. I also think that with the other protections and notice and consult that are included within these protective regulations that we've created, I think that we're in a good spot to allow for this to continue. I would note that one of the things that has been raised to me as a concern is that when an operator proposes to use a location that received preliminary siting, it still needs to get an oil and gas development plan, but the director's recommendation may come out and then very quickly thereafter it comes to us. And so this is where I'm putting in the concept that there should be within the 300 series rule something along the lines of a notice period of maybe approximately 30 days where the director's recommendation will actually be noticed to the RBU so that they have an ability to, beside the notice previously given at all the other notices stuff around the DIR director's recommendation for the utilization of a CAP approved preliminary siting. Next, standards for setback criteria. If I've counted it up correctly, the new 604B4B, which is the DIC substantial equivalence setback off-ramp, has approximately 16 criteria to be analyzed by the commission when an operator desires to locate an oil and gas location within 2,000 feet of an RBU and a DIC. Some parties desired an express call out that for those that use the hierarchy, we actually use the verbiage that we've been talking about this morning about avoid first, minimize what you can avoid, and then mitigate what you cannot avoid or minimize. Other parties did not see a need for this call out. I'm calling out in the SPP expressly that the hierarchy is correctly applied in all instances. That is this hierarchy right here. And that's something that we discussed earlier with AG Stafford. I believe that with that in mind, we don't have to put verbiage around each of the criteria in the 604B4B criteria, but we know that when we are evaluating it, we're doing this hierarchy evaluation as called for in the SPP, and then later on down the road, I think it's likely we'll have a rulemaking around that topic to make sure that it's applied appropriately. All right. Some parties desired an express finding that the substantial equivalent setback finding cannot occur unless the commission finds that this is the only location to extract the minerals. Other parties opposed to this approach because multiple locations are generally approachable, and the best location may not be the only location that the minerals can be developed. I tend to agree with the latter point, and I don't think it's appropriate to require that the only location can be developed because it tends to elevate potentially subsurface and economic concerns over public health, safety, welfare, and the environment, and it discourages best siting practices. So while I understand the thought here, I did not believe that it was ultimately a game breaker, and I felt like with all the other protections contained within the setback that we're still getting to a very high level of protection for DIC, assuming that they're trying to use this setback off-ramp. Okay, another issue was we are requiring no tanks, pipeline takeaway, lay flat water pipelines, and where practicable, electric and no water in tanks. Some parties desired the hard effective date of January 1 for everything. Other parties desired an effective date for any application filed after January 1 of 2026. I had a concern about the any application filed after January 1, 2026, because if you file an application, say in the summer of 2026, it may not be approved for another 6-9 months. It may not be drilled for another 2 to 3 years. And so I believe that this language captures the flavor of giving a little more runway for hard to change best practices, while at the same time ensuring that we're going to get compliance with these requirements earlier. So it would be 316C4 apply to all new construction on oil and gas locations on or after January 1. So all new construction based upon a Form 2A approved on or after the effective date of these rules. This captures the year's delay of application of the hardest to use BMPs and accomplishes the goal, I think, in our mind that we're trying to accomplish. All right, some parties wanted all ESPs to always apply. Other parties desired carve-outs for electrification and use of storage tanks for produced water under a practicability standard. That's where I suggested we go with the last draft. I still think we go with that carve-out, but importantly, I would add in a third requirement, which is the use of electric drill rigs unless they can be proved to be not practicable. So this is a significant add to the things that need to be done unless they're not practicable. And then if you look at my red line language, I've developed some additional practicable assessment language. There's now 4 or 5 different categories of how we as commission will determine practicability. And so some parties that ask for less robust language, some parties that ask for more robust language, and I've come up with language which I think accomplishes the goal there. And then I didn't want us to lose sight of some of the other things that we are doing around protections for DI communities. Some parties wanted strengthened and more robust community liaison provisions. We've done that in our draft and in the work that we've done, and we want to thank the parties that asked for and articulated that in the pre-hearing briefs for helping us, I think, get to a really good spot. Some parties also wanted strengthened and more robust notice and consult. That too, I believe, has been accomplished, at least in my mind. And I'm not deliberating yet. I'm just providing some perspective that I think we've done a good job listening to parties about that issue. Green Latinos particularly advocated that we bring in the potential for community benefits agreement, and that is within the 604 substantial equivalent setback that we've put together. Green Latinos also expressed that they would like to see the DIC protections in one rule. I had articulated at the previous hearing that I was drafting with the AAGs a Rule 317, which gathered all the other protective mechanisms for DICs and put it in one rule so that we could get one place. My AAGs won out, and they were not comfortable that that was a good way to go about creating rules because there was too much duplication, there was too much overlap, and there could have been inconsistencies in application. So in talking and trying to come up with a notion that provides guidance along this, I think that the idea of a guidance document that is in layman's language that can establish an understandable format for how it is that our rules are protective on DIC makes a lot of sense and could be something that we could work through. These last couple of ones are pretty minor, but so that in the 316, one of the ozone protection measures, which I'm not sure I quite understand how sandbox mitigation technology is an ozone precursor mitigation because it deals with silica and dust. But at any rate, the way the rule is drafted right now, it says that there'll always be closed loop sandbox technology. And that's one method for dealing with sand management technology. I've just broadened it to say sand management technology and procedures, including but not limited to closed loop. And then in the draft that I had created, I noted that 604, the first 1 through 3 remain applicable. I think it would be helpful to have that clarified in the SBP. And then also this is the 604B4B1AA. That's the DIC ALA process. And I think it would be helpful for the SBP to clarify that's the same analytical process as the general ALA process. So, commissioners, that document is also in, hold on, I think I need to stop sharing, in the portfolio. And the red lines that I've created remain in the portfolio. And those are the things that I wanted to provide to you and to our stakeholders on the work that has been accomplished on these important topics over the last week and a half or so. Happy to take any questions now. Happy to also break for lunch and give you a chance to dig in a little deeper. It is any questions? Commissioner Cross?
Thank you, Mr. Chair, and thank you for the hard work on this. Trying to dig into a little bit of these. I wanted to just ask a couple maybe clarifying questions. On 604, you have not the best efforts, not the good faith, the reasonable efforts. And I was kind of curious. One of the things I liked about the good faith that was brought up, I guess not last week, the week before now, was there's kind of an existing legal standard with respect to good faith. And so I was kind of curious your thoughts on this shift from the existing legal standard from good faith to, I think you called it the reasonable.
Yeah. No, I appreciate that. I had some discussion with the AG Davenport, and if he wants to visualize in, that would be great because he's the lawyer and I'm not at this point. But part of the discussion was we felt like good faith efforts was kind of at this point, best efforts was, at this point, best efforts at times, and I'll let AG Davenport explain. My understanding is that it can almost be something that you cannot get past because it requires such an assessment that you're not getting beyond it. And AG Davenport and I both felt like reasonable efforts was somewhat of a middle ground. And having said that, AG Davenport, do you want to weigh in further on how you helped me get to this language?
Yes, I'm happy to. I think, as the commissioners are aware, there was a suggestion from some parties to use the term good or best efforts as opposed to draft rule language of good faith efforts. Best efforts, depending on case law, brings in a concept of has been otherwise defined as all conceivable efforts, which in my view is a high standard. Much higher than good faith efforts, which I think this commission is familiar with. It's in other rules as well as in the act that brings in, in my view, an element of intent. Was there an intent to achieve the goal of the notice or whatever it may be? And I think by using the language, all reasonable efforts lands somewhere in the middle there. It wasn't just there was an effort, it was made in good faith. It's not every conceivable effort. It's all reasonable efforts. So whatever that may be, reasonableness depends on the context, but the all includes more than just one attempt potentially, in my view, and it requires that the operator go beyond just making an attempt in good faith with the intent to try to reach someone.
And I would point out, AG Davenport and to Commissioner Cross, I believe that we can allow AG Davenport working with the other attorney generals to place within the SBP language that helps clarify what we're intending here. And then obviously, as with all things commission, as we look at applications that may come through, we'll start to generate some case law, as you will, around what that actually means. But I think we can flesh it out with some of the language you just used, AG Davenport, in the SBP, to show folks how it is that we're trying to create a standard that really is a protective standard and establishes that it's meeting the mandates of the statute in terms of protections to DSC.
That's helpful, and I think language in the SBP would be helpful for that as well, because as AAG Davenport noted, I think that we do have existing use of good faith and kind of an understanding of what that entails. So I think some explanation of what that's intended to entail will be helpful as well. And then the other one that I wanted to, less of a question, and I appreciate it, and I think it's good to talk about in the statement of basis of purpose as well, is the idea of continuing to have those, I think we called them the off ramps under 604, the informed consent, the remember what all three of them are now. I'd have to look again. But with the informed consent, the
the comprehensive area plan, and then
Yeah, and then
the equipment is moved further away.
But yeah, so those I think it's also important to note in there, and include in the statement of basis and purpose as well, that all our additional protections are still applying, including if you're in a DIC, we're still having those enhanced systems and procedures still going to apply, because it's in a DIC as well. And so I think it's also important to note that. So I'll just say I agree with that, and I think it's important to highlight that being in there, those off ramps existing does not change the protections that exist elsewhere in the use.
Yeah, I appreciate that point as well. Other points or questions? All right, 12:20. What about a 2:00 return time? Hour 40. Let's do it. See you guys at 2:00. Okay, welcome back. It is Tuesday, October 8th. It's 2 p.m. This is the Energy and Carbon Management Commission. It's docket 2406-00145, Cumulative Impacts and Enhanced Systems and Practices Rulemaking. And all 5 commissioners are back. Commissioner Shea will be joining us in just a bit. So, commissioners, I think we need to process out next steps. I think what we talked about before we broke was give people a chance to look at things, and then we would. I think the right thing to do here, and so we got 2 things that need to happen, or maybe 3. One, we need to give each commissioner the opportunity to bring out sort of remaining big ticket issues, substantive issues. We also need to give commissioners the opportunity to focus in on language. And I'm wondering, so we can do one of 2 things. We could let commissioners define out what they think are big ticket issues, or we could pull up the current draft and start at the beginning and not like focus on each and every page, but just like if we're looking at pages 1 to 10 and Commissioner Oath has an issue on page 6, she could say, let's start at page 6 and let's take a look at my issue on page 6 and proceed that way. There's no right, wrong, or otherwise approach. Does any commissioner, I guess maybe to start, I'd ask commissioners if they feel they've got something that's kind of big and substantive and is not like pagination oriented, maybe we should start like there. And I know Commissioner Messner has at least a few of those.
I mean, I'm happy to bring up a couple of things. I do like the idea of actually going page by page at some point. Some pages we'll just skip through very quickly because there's nothing on it, but then I think we've methodically hit everything so that we're not jumping from page 6 to page 3 to page 12, which messes my brain up. And so I would request that.
Do you think your initial things, Commissioner Messner, are substantive or big enough that they ought to be taken independent of moving through the draft?
I think my stuff can be, we can do it as we go through the draft, and there will be situations where my bigger concepts will hit multiple pages and sections in the draft, but I can introduce those the first time that I have like a red line language in there where I can say, okay, this is an example of where I will be continuing this thought through the draft.
With that being the case, I think that's my vote and Commissioner Messner's vote to start page by page and just hit them as we go. Does anybody have a thought that they've got a substantive issue that really ought to be talked of before we move through the document?
No, maybe just one clarifying. If we do go through the document, are we going through like the clean version?
Yeah, I would. I talked with AG Stafford over the break, and she and I both felt that it probably makes sense to go current red line to or most recent red line to current rules, and not as to the August draft. If we do the most recent red line to August draft, there will be places in which current rules don't show up. And so you don't get the whole deck of cards picture. And then AAG Stafford, if you could show up. I just realized something. The stuff that I posited this morning on 604 and 316 aren't in your current draft.
That is correct. If you want to give me some time once we started going through things, take a pause, maybe if we get to a place where we can pause, I can incorporate that.
I got a feeling we're going to not get to 316 before the first break. So we'll take a long enough first break that you can incorporate those changes at that point. Is that fair?
Yep.
Okay. All right. Then do you want to pull up for us current rule red line to current or most recent red lines to current rules? And Ms. Trask, if you could show up. You're partially our scribe. Are you cool with this approach?
Yes, I'm fine with this approach. I would defer to Ms. Stafford to actually catch the changes on the fly in the document that's on the screen.
Well, and I would also ask that hearings officer Thomas and or AG Davenport and or hearings manager. Oh, I don't think the other hearings manager is with us, but if everybody could keep notes, and we'll compare everything at the end, and that way we won't miss anything. Is that fair?
Yes, Chair.
Yes.
Okay, so we're on page 1. What page does somebody want to focus us in on in the first 10 pages, say? Commissioner Messner?
So this may get a little complicated. So my red lines are in the clean version. So I can tell you that on the clean version on page 4 is where my first one is. So if anyone has anything before that, jump in, but that would be rule 224 community liaison. I do have something on page 4, which is C11. Anyone have anything before that?
Anybody got something before that? I'm making the thing small so I can see everybody. All right, then let's go to that rule.
Okay. Well, so we had talked about when we were initially giving direction about the ensuring that the operator maintain the burden of proof throughout the rules. And so I think that the language is a little bit funny in 11. And so part of this is probably the way that I wrote it or in my red lines when I provided this, because I didn't cross through some stuff. But right now it says providing to the director for inclusion in the director's recommendation, a written summary that includes a description of the operator's efforts to engage disproportionately impacted community members and the perspectives of the disproportionately impacted community members regarding the operation proposed in the oil and gas development plan application. I'm a little worried that could be interpreted as the community liaison having to write the summary of the operator's engagement versus having the operator write the summary and the community liaison reviewing that and providing a written review of the operator's engagement. And so I changed the language simply by saying in line at the end of line 1 and line 2, a written review of the operator's efforts to engage DIC community members, blah, 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 and just struck out a summary that includes a description. And that may not be enough, but understand my intent here is to ensure that the community liaison doesn't feel like they have to write the operator's outreach summary, but that the operator is actually doing that and the community liaisons reviewing that and providing any relevant comment. I thought that that's what we had talked about at our last meeting, but I'm open if someone disagrees with me.
Could we accomplish your goal by just saying a written summary prepared by the operator?
Yeah, I just want to make sure that, I mean, the intent here is that to get the community liaison's eyes on it and provide comment, if appropriate, to be included on that, just indicating whether or not it was adequate, it was good, there was anything that is important for the commissioners and staff to know as part of that, as part of our review of the application, so that we have that. It's essentially a consultation with the community liaison on the operator's efforts to engage DIC community members. I think that's important, but I want to make sure that the operator is writing the report and the liaisons reviewing that and providing any perspective or comment to that. And so
you want to make sure that it's clear that it's a written summary, that it's the community liaison's written summary of the or review.
Yeah, I'm just suggesting a written review of the operator's efforts and
but you also want the operator to provide the community liaison with that summary in writing.
They have to, right? I mean, it's the community outreach plan. They're reviewing the community outreach plan and other elements. And so to me, this is because again, we're talking about roles and responsibilities of the community liaison, right? And so I don't want the community liaison to feel like they have to write the community outreach plan for the operator. That's really all I'm trying to say here, so that it's clear. That burden maintains with the operator, the community liaisons reviewing those efforts, the community outreach plan, the public meetings, whatever is in the application, and just providing a review or a consultation on adequacy of those efforts to help us in our decision making, whether they've met that requirement or not.
Ms. Trask?
Commissioner Messner, we do have language in, sorry, scrolling, 301G 1E, results of the director's pre-application meeting, 301G2, no, it's in there somewhere. 301G2B, Romanet 5, little v. So the bottom of page 8, the written summary. And I'm pretty sure we have this written summary requirement for both the pre-application community meeting and the post-completeness community meeting. The requirement for the operator to provide to the director a written summary of both of those meetings. That is, those would be attached to the application, either before the application comes in, or in the case of the post-completeness meeting that would come in, would be emailed to staff, and staff would attach it to the Form 2A. So there are 2 written summaries of the outreach between the operator and the community members for the 2 community meetings. Yes,
and I know this and I acknowledge that. And so in here, I'm trying to just say, I can read this as saying that the community liaison needs to write like the efforts, right? Like and maybe it's just semantics, right? So I'm just trying to make it clear in here that they're reviewing the operator's efforts and providing a summary, not writing the summary, like not doing it for the operator. And that's all. And if you guys are reading it, that the way that it is that it's clear that that's not what the community liaison needs to do. I'm not going to get hung up on this, but I just wanted to make sure that that couldn't be read that way or create any confusion.
AG Stafford, do you want to provide lawyer perspective since this is lawyer drafting issue?
Sorry, forgot the mute button there. I think, I mean, as written, this is a little circular. I think Commissioner Messner's red line appears to accomplish what the purpose of this subsection was supposed to be. I don't know if my colleague, Mr. Davenport, has any thoughts on this one.
Can I ask how we're going to do this afternoon question? So, having been involved in lengthy iterations of trying to craft language on the fly, that's one way. Another way is craft the language when it's simple and then drop in comment bullet or bubble comments that captures the essence of the point, and then let the lawyers draft outside of an arena before 75 people. I'm happy to sort of do both as we move through this. Commissioner Messner, you're well versed in this as well. Do you have a thought?
I'm trying to make it easy, so that's why I put the red line in there. And if everyone's good with the red line, we should give it a thumbs up and move forward.
Let's thumbs up and move forward. Somebody pipe up if you've got something between pages 5 and 15. Commissioner Messner?
Okay. So this will be purpose and content of the director's pre-application meeting. So I'm all the way on my page 6, 301 G1A. And so I guess I want to start with a question, and this is a question I didn't get to ask staff, or I forgot to ask staff, but my red lines had taken out the director's pre-application meeting as a formal consultation process because I had kind of indicated that, generally speaking, there are local government land use review processes that have a formal pre-application process, and most of them have an informal pre-application process. I guess I want to understand like the importance of keeping it as a formal consultation process versus an informal consultation process.
I can take this one. So Commissioner Messner, formal consultation process is defined in the 100 series as a process for soliciting and receiving meaningful input from the consulting party or parties, with opportunities for in-person meetings, and to allow a back and forth discussion and a good faith effort to incorporate feedback from the consulting party or parties. And we thought it was appropriate to leave that in the purpose and content portion here, because that's our understanding of how this meeting should go. We understand that you have the commission directed us not to or to adjust these pre-application meetings in line with your red lines, which were to ensure that this was not a place where a decision was being made in the pre-application context. And I think that our edits accomplish that here. So we thought keeping the formal consultation process at least set forth the expectations for, this is a meeting where people will receive meaningful feedback, and, people will make a good faith effort to incorporate that feedback going forward. So that was our thought there.
Okay. So So I understand your intent. I am a little worried that utilizing the definition of formal consultation process, which was intended to be post-completeness consultation in the mission change rulemaking, may infer that consulting parties, particularly CPW and CDPHE, need to have the necessary information in front of them in order for them to engage in a formal consultation process pre-application, versus an informal process where ideas are being thrown out there and concepts are being, contemplated, and issues are identified. And I mean, that's an informal pre-application conference. No decisions are being made, but lots of things are being talked about and thrown around. And so I guess I'm a little worried with the formal consultation process for that reason. But I may be on an island on that one. So if anyone else has other thoughts, I'm open. Okay, then I'll move on.
Sorry, before we move on, is the direction here to strike that sentence, or should we leave it as is?
That's what I have in my red lines, is to strike that. Now it could be replaced with an informal, language that's an informal consultation process, because it is informal, and it's okay to indicate that it's a consultation process. But I don't know that formal consultation process. I worry that it's going to conflate with the true post-completeness formal consultation process. Well, I go either way. It might be easy just to strike it.
Yeah, I mean, I think if you, I guess I don't have as much concern about that. If it's struck, it's not considered informal or formal, and the purpose is defined in the very next sentence, which is fine with me. I guess I don't have that. I'm not struggling over the words as much, but so I guess I could be fine with striking it, so that we're just allowing it to self-evident what the purpose is, and it's as articulated in the next sentence.
That was why I suggested just striking. Yes.
Okay.
The other section, and this is I'm throwing it out there, so I don't think I mentioned this yet, but and this will come up in another section around default area of evaluation. But if you look at Roman at 3BB, and it talks about the default area of evaluation, and generally I'm okay with leaving that pretty broad, but I want to, at least my understanding is that there's some interest in getting some thoughts and feedback from CPW and CDPHE in this pre-application meeting. And so maybe that doesn't need to be indicated there, but maybe it would be helpful to have, consideration of input from CDPHE and CPW on the area of evaluation as part of BB. They are part of the invitees to the pre-application meeting, and so it might be inherent that they would provide thoughts on that. But I'm throwing it out there. I'm going through my red lines. So
Mr. Chair,
go ahead.
Thank you. I saw this as well, Commissioner Messner, and then, the way that I thought about it when I struck this off my edits was that this is what the operator is showing up to at the original meeting, and they're going to say, these are what this is what we've evaluated in the default area of impact, and it gives CPW and CDPHE an opportunity to take that in. And then later in the regulations, they're afforded the opportunity to suggest expanded area of evaluation. But I agree with your point that hopefully those discussions will take place at that meeting. I don't know that they necessarily absolutely will, but might take place after some evaluation of what the operator has presented. And so I ended up leaving this one alone at this point.
Commissioner Cross?
Thank you, Mr. Chair. I don't see a need to change this either. I think that adding in that level of detail is superfluous. I think that it provides the opportunity to talk about the area of evaluation based on what we heard from especially Ms. Trask in terms of what happens at these meetings already. I think that that's understood, that that's something that will be discussed. And I would anticipate that it would be discussed, but I don't know that we need to put in something that goes into the level of detail of discussing that much more other than saying the default area of evaluation will be discussed.
Agree.
Okay, like I said, I'm not hung up on that one, so I bring it up just for discussion. And then another question for staff, maybe AAG Stafford. Like you indicated before, I mean, one of the things that was talked about was that, you know, the concept of this being informal consultation, you know, all the purposes that are in there, but that no decisions would be made. But I'm not seeing that captured in the language, and I could be missing it. So I'm just asking for where you think it's that concept is captured.
Thanks, Commissioner Messner. I think as we were making these edits, it seemed more appropriate to explain that in the SBP and to say that it's the commission's intention that there are no decisions being made at this meeting. Based on the way that the rule is written, when I'm trying to draft these things out, I want to include the things that seem to be very necessary for staff, and potentially leave those things concerning commission intent to the SBP. So we felt that with the way that the process was described, it didn't need to necessarily be in the rules as drafted. But obviously we will take different direction if that's where we need to go.
I'm actually okay with that particular piece of the SBP, that it is clear and that kind of the intent of the pre-application get fleshed out well in the statement of basis and purpose as well. And so I'm okay with that. I'll pause there because my next thing's not for a few pages. So,
Commissioner Ackerman?
Thanks. I'll jump right in there in that same regulation down under, excuse me, C and D. That's timing of the director's pre-application meeting and waiver. And I'm working off of a differently paginated draft as well, so we'll work through it. I was just going to flag in C there, the timing of the director's pre-application meeting. It states the director will hold one or more pre-application meetings. I just thought that was a little awkward, at least one. And I just wanted to flag that instead of, I can't really see, I think that might be a distinction without a difference. And so I'm probably okay, but just wanted to flag that for the AG's office to see if they see a distinction between at least one or more. Under D, I'm a little concerned about the last sentence in D, and I think we can maybe clarify in the basis and purpose statement. This is the regulation that gives those that are afforded an opportunity to participate in the pre-application meeting as listed under the regulation that's cited there. That's, CPW, local government, CDPHE, and the others that are included there. And then it states that they can waive that opportunity. And then the last sentence says any person may reinstate their right to participate upon notice to the director. And I think that it probably is important for us to point out again, probably in the statement of basis and purpose, that doesn't mean that reinstatement then allows for retroactive process that they missed during the waiver period, if that makes sense. Is that making sense to you, AAG Stafford?
Yes, Commissioner Ackerman, I think I understand what you're getting at. What I'm hearing is you want to ensure that the process doesn't have to happen again simply because this one particular party decided to come back into the fold.
Right. If they reinstate, they do get to jump back in, but they get to jump back into the process where it is at that point. And that's all I have for that regulation, Mr. Chair. I don't have anything for a little bit.
Anybody have a concern with that? Okay. Who's next?
So I can go next. I'm on page 10. So under 303 E1B, under notice. So who received notice? I'm wondering if
Just for the record, Commissioner Messner, that's page 15 of the one we're working off of.
okay.
And I know your notes are in the other one. I'm just going to try to keep us moving to the right page. I'm going to, because I got the other one up.
Sure. I'm wondering in this one, and this is the completeness determination notice. We talked about when we were determining who needs notice, when they need notice, how they need notice at the last meeting, that during that pre-application public meeting, community meeting, that people would be able to sign up for electronic notice of stages. And so that we felt like this one was captured because of that electronic notice piece, but I'm not sure that's captured in here. And so my suggestion is to place the same language that's used in other sections, which is any person or entity that has provided a comment electronically pursuant to Rule 303 D1 or has provided email addresses per the community meeting rule would get notice on here as well. And that's not very elegant, but I think understanding the intent there is if they signed up to be notified by email at the pre-application community meeting, then that should follow through on all the rules, all the notice pieces that are appropriate moving forward. I thought that's what we had decided at the last meeting.
And so this seems to be more inclusive than that. It's any of these folks within a half mile or within a mile. So are you suggesting you would want something that's less inclusive? It's just those people that provided their email notice?
In addition to those. So we've got the ones that are in there, right? And then all I'm saying is that there are people that could have been at the community public meeting that provided their email address to be able to be noticed about things that are happening, in this application. And so I thought that should be included at any place where the community is getting notified. And so that one's just an email, and maybe this one doesn't fit because I mean, I think this one's still accomplished by an email, right? I don't think it's a certified mailing for the completeness determination. So I thought that it would go out to the whole email list, but maybe I'm confused.
If I may, Commissioner Messner, are you suggesting that the groups of people identified here, we might potentially be missing a grouping of people based on how this is written above?
Yes, that's what I'm trying to say.
Okay, and then also just for the record, current Rule 303 E3 sets forth the procedure for providing this notice, which electronic mail is one of the things that can be done. So
yeah, and so that my intent is clear, I've been involved with a couple of different land use organizations, local governments, that if you are interested in what's happening in an application and you want to be kept appraised of that application throughout the application process, either because you're curious about it or you want to engage in the process, have the ability to sign up to receive email information about different steps in the process. And so that's, I think, what I'm suggesting here is to have that, that opportunity was clearly laid out in the pre-application community meeting, and that to be able to provide your email to get future emails about different steps of the process as the application works through those steps. And I just want to make sure that completeness includes that, as well as the folks that are within a half mile of the working pad surface or within a mile of the working pad surface within DIC. And I understand I'm getting granular, but I do think that if someone's interested in following the application process and we're setting up a way for them to sign up via email at the community meeting, then we need to follow through that and all those steps of the rules.
Chair, if I may ask a clarifying question.
Yeah, I was about to ask you if you saw any unintended consequences.
I just was wondering, Commissioner Messner, are you're including the general public in this as well? Anyone who attends the pre-application community meeting?
Well, I think the pre-application community meeting rule states that if you sign up to be, it doesn't specify who can sign up to have email, to put email on their email list. And so I would assume that would have to include the general public.
Okay. Thank you for that clarification. Chair, I don't particularly see an issue with this because as AAG Stafford mentioned, the current rules allow for that notice to be sent by the operator via email or via, postal service. So I think the operator has some flexibility on how they will provide that notice. And that will be based on what information was provided by the folks who attend the community meeting.
And Ms. Stafford or Ms. Trask, does expansion of this, which I don't have a concern with, if people provided an email notice so they could be kept up to speed with something, that seems like we should make sure they're kept up to speed, which I think is what Commissioner Messer's point is. But this doesn't create any unintended consequences around standing or additional opportunities to be involved, right?
I will defer to the legal team on standing. I don't believe that there would be any unintended consequences with allowing people to receive information. And I think that Commissioner Messner is asking that this would occur with the OGDP completeness determination and presumably also the CAP completeness determination. I think if people want to know what is happening in the status of a permit application, this is one mechanism that they can become informed. I think that it will be helpful for them to understand what future opportunities they have. This completeness notice tells them, it gives them the application, it gives them a link to our website where the application will be publicly accessible. And it also notifies them of the opening of the public comment period. So I think it's probably a good addition.
Anybody got a concern with it? All right, let's move on.
And Mr. Chair, if I may, sorry.
Please.
I don't think that this implies sorry, my brain just stopped working, party status or anything. This is just to provide information. I don't think this grants the recipient any sort of additional standing in the procedure.
Okay, and that was just my clarifying point. I think we've done a good job of establishing well-defined standing requirements within our rules, and we purposefully tried to keep those at the place that they're at. Commissioner Cross?
Thank you, Mr. Chair. I'll just say I think this is also consistent with what we talked about, and I know that we talked about non-certified mailing as well as an option for those that may not have access to email as well, so providing that option. So I think that's part of our understanding from our quote-unquote consensus before as well. If I could just go back for one clarification on the previous provision, 303D. This is where we've changed to the 60 days within 4,000 feet of an RBU within a disproportionately impacted community, and then we have 45 days. Just want to check to see if anybody wants to clarify the BB under 2 for the 45 days. It says within a disproportionately impacted community, to clarify that that's within a disproportionately impacted community, but not within 4,000 feet of an RBU or high occupancy building, et cetera. I think as is, it's fine, but I did note it as just having the disproportionately impacted community in there again.
I thought that's what our intent was on this one, because it's, it's a public comment piece, and so it's disproportionately impacted community-wide.
And I just wanted to make sure that's where we were, because we do have the 60 days when it's within 4,000 feet within a DIC, but just wanted to make sure that there was no hesitation about not clarifying that.
45 days if it's just in a disproportionately impacted community, 60 days if there's a proximity.
Correct.
And I think that's what we determined.
And that was my understanding as well, but just having the DIC again, just want to make sure we don't want to clarify that it's also within a disproportionately impacted community, but not within 4,000 feet for the 45 days. But don't think it's necessary. Just wanted to make sure that no one had concerns as I noticed that as potential confusion.
Okay, seeing potential confusion clarified, I think we can move on.
I've got 304, so there where you're at. Well, sorry, it's 304B2A Romanet 1 double A. And so this is going to be a little bit of a philosophical, bigger thing that goes through the what I'm hoping is able to be captured throughout the rules. But so if I haven't made it clear yet, the director's recommendation to me is really, really important. And what is included in the director's recommendation, the rationale of the expert staff that we have and the consultations from the expert agencies that we have, clearly captured with findings and understanding. In order for me as a commissioner to be able to understand how staff came to the conclusions they came to, the level of information and not just that it does meet the rules, but how it meets the rules ends up being really important. And what I'm going to talk about here is it's a really minuscule thing, but it kind of carries through here so that it helps me understand how staff came to that conclusion. It allows me as a commissioner to utilize the expertise of the staff in my decision making, because I'm able to pull from the director's recommendation how they came to the conclusions that they did and the findings that they determined and how it actually is protective minimizes adverse impacts, and applies the mitigation hierarchy and all the different things. And so in this one in particular, the suggestion would be that if in AA there, to ask that the finding, should the director determine that an alternative location analysis is not necessary and waives that alternative location analysis, in the director's recommendation, there could be a finding or clarity, a showing that shows how the director came to that determination. That would really help me understand, why they waived that alternative location analysis, would allow me to understand the expertise within the organization that got utilized to make that determination. And then that makes me, as an independent reviewer of this application, in a much more stable position to be able to agree with that director's recommendation or not. So I'm asking for a finding to be included if the director waives an alternative location analysis in the director's recommendation. And so I'm down a little bit from where it is on the, I'm on 304 B2A Romanet IAA. Is that where we are on the screen? Right there.
So Commissioner Messner, this is current rule language, which is why it's not in what I was working off of. So we weren't suggesting to change it. So I think what you're suggesting is now a change from what is currently in place.
That's correct.
Okay.
And so, again, my intent here is to build out the director's recommendation in a way that helps me utilize the expertise of the staff and of the consulting agencies in a way that clearly lays out like how they came to the decisions that they came to, and so that's why I'm bringing it up in this. And this is a really small piece, but there are different areas within the rules as I went through the rules, because I went through the entire clean version of the rules after the adjustments had been made and tried to view it as I would view it if we had just adopted these rules. So I'm not looking at the red lines, I'm just looking at the rules. And this was jumped out at me that if a director makes a recommendation to waive an alternative location analysis, that's great, but I don't have any information as I'm reviewing it as to why the director waived that alternative location analysis. It's not generally found in the director's recommendation. There may be something in the application down deep, and I do read all the applications, but I guess I'm asking throughout this rulemaking to help the commissioners in that director's recommendation by utilizing findings and explaining not that they meet the rules, but how they meet the rules, allows us as commissioners to utilize staff's expertise in our decision-making in a way that I'm not sure currently happens. And so that's my ask.
And so, Commissioner Messner, I'm sorry, I'm struggling to follow you. What do you want to change in the current process rules?
So on this page, and so again, I had mentioned that this will carry into a number of different sections in the rules, but in this one in particular, all I'm saying is that if the director, so this is in 304B2A Romanet 1 AA, if the director is waiving an alternative location analysis, that there's just a finding in the director's recommendation as to why that is and how they came to that conclusion. That's all. in this section.
Okay, but that's all of what sounds like a larger approach to current process that you're advocating for. And if
Well,
that's the case, I'd love to hear kind of the grand scale approach to changing our current processes that weren't necessarily what we were focused on. I'm happy to focus on them, but just if there's a grander redo of our process that you're envisioning, I guess I'd like to hear the whole vision as opposed to cherry picking off a.
Well, the whole vision is there'll be different sections, and this is the only place that I'm aware of that it's current rules. The rest of it is in newly drafted rules. But this is a current rule that this particular section applied to. But there will be areas where, you know, when we get to the sections around, you know, director's review of the oil and gas development plans, right? Or director's review of the comprehensive area plans, including the commission's review of those sections as well, that there be some mention in there about how the director came to the determination to recommend approval, to recommend denial, to recommend conditions of approval, and like some clarity in there as to the different findings on how they feel like they met the different sections of the rules. And so whether it's cumulative impacts analysis that, you know, ultimately is asking that applicant to avoid, minimize, and mitigate, you know, cumulative impacts and to make a showing of that. And so if the director in their review of it believes that the operator has successfully done that, it would be good to have some findings on how that happened so that I can look at the director's recommendation. I can cross-reference that within the application, and I have, you know, I am then able to utilize the expertise of staff in the review of that piece of it. So that's in an OGDP application. And so, I mean, Chair Robbins, you know this from your time as a county attorney, that findings are something that are critically asked for by county attorneys in staff reports that go to planning commissioners or county commissioners in determining whether or not an application has met the standards of the land use process. And so I'm asking for some of that in the director's recommendation so that I can go through that same check and balance and make sure that I'm utilizing that expertise of the staff in my review process and clearly understand how staff came to the conclusion that they did. And so that's really the conceptual piece here.
Ms. Trask, I want, you know, obviously this is getting into, well, it's not your world anymore, but it's Mr. Frizzell's world and a lot of staff's world. So would love to hear you weigh in on this vision that's being articulated.
Thank you, Chair. I might ask Commissioner Messner, if we were to add another subpart in Rule 306. 306 is the director's recommendation of an OGDP. And we've got some language currently drafted in there that says, you know, what the director will base her recommendation on. Would it be helpful if we sort of created a new line item, a new list that says a new list that identifies wherever in the rule that the director can make some sort of unique finding, whether it's excusing the operator from having to perform an ALA, if it's making a change to the area of evaluation, you know, whatever those kind of director determinations are throughout the OGDP review process, to have that list itemized in 306 so that when the director's recommendation is issued, we'll have an indication of, okay, did the director make this decision? Did they make this decision? Did they make this decision? And where those decisions are made, then those findings are identified in the director's recommendation.
Yeah, I think that would be super helpful. And that's kind of what I'm looking at. And so it's not only those decisions to like waive something or alter something, but also in review. For example, like to me, the cumulative impacts analysis is the plan that rules all the plans. I think it's been like that since the mission change rulemaking. The mission rulemaking set up 304C19 to be the cumulative impacts plan that was supposed to be the plan that rules all the other plans, that all the other plans spoke to. And the operator in that cumulative impacts plan was to identify how they're evaluating and addressing cumulative impacts. And, you know, ultimately applying the mitigation hierarchy in that process. And, you know, I think there's an opportunity to develop a finding as staff is reviewing the cumulative impacts plan to say, we feel like the cumulative impacts plan does, you know, meet the requirements of the rules and, you know, minimizes direct and cumulative impacts to public health, safety, welfare, the environment, wildlife, resources, you know, for these 5 reasons, and you know, really show how, you know, whether it's, you know, offsetting beneficial impact to, you know, an existing impact, the you know, a highlight of some of the, you know, bigger BMPs or enhanced practices that are being proposed in there, you know, the particular siting of the location. I mean, you're pulling pieces out of that cumulative impacts analysis. You're explaining things that were important and impactful to you as far as how you made that determination. And you're indicating that in findings. You know, you've got a recommendation from CPW that said that they, you know, should have a timing stipulation in there, or that they're doing, you know, mitigation work in a certain area in order to develop the wildlife. To me, that shows how the operator is, you know, properly evaluating and addressing cumulative impacts. It's clearly laid out in the director's recommendation. It helps me as a commissioner review that application, understand where staff's coming from, utilize staff's expertise in the 6 or 8 months that they've had to review that application, and allows me to like target different pieces in my review of it. But it also gives that same benefit to the public and any other interesting parties, you know, as they're reviewing the application as well. And so I think that just ends up being a really important piece. So what you're recommending, I think, is a really good piece. And so there'll be different sections in here where I may, you know, recommend certain rule language, but then I think this can also be talked about in the statement of basis and purpose, you know, about how findings get developed and, you know, the importance of the director's recommendation, you know, in these topics. I really think, as I'm trying to express, that, you know, this is pretty standard staff report, staff recommendation process for land use planning. It really adds to transparency. It really is, you know, creates some solid legal footing as far as how staff is making a determination that they can utilize in any challenges to a decision that this commission makes. And, you know, I think it's just good practice. And so I'm just trying to incorporate that in.
AAG Stafford, AAG Davenport, would like to ask you to weigh in on the things that are being contemplated here, that at some point there are, because Commissioner Messer just pointed out, some of these are part of sort of the new rules. Some of these are not. This is not a normal process rulemaking, or is it? I don't know. I'd like to get some input from you guys on that issue or those issues.
Sorry, I don't see AAG Davenport popping up, so I'll at least put in my 2 cents here. I guess what I'm hearing, I understand, you know, the practical benefits and, you know, positive things that could result from a change like this. I think I would just, I mean, I'm working here as staff's attorney. I would obviously defer to AAG Davenport here, but I just want to caution on potentially making changes that have not received stakeholder feedback as part of this process. So just want to be careful there.
I'm here, Mr. Chair. In the event you
Go ahead. Thanks.
I think the caution is a good note. I think discussion is certainly possible. SPP language, in my view, would be preferable if there is a concern about something not having received stakeholder feedback. So that would be my suggestion. But I'm happy to hear further discussion or questions about that topic.
Fellow commissioners, further discussion or questions on the topic? Commissioner Oath.
Thanks. I mean, I guess briefly, I would say what Commissioner Messner is suggesting sounds like it would be a very helpful tool, right? Further understanding kind of the thinking behind some of the conclusions that the director and her staff have come to is helpful, I would think, for myself as a commissioner in further deliberations. So I think so long that does, I mean, not opining on the legality of it here, it seems like that would be within the scope here. I think if that's what we're concerned about in terms of the legalities of it or input, I would be comfortable with moving forward in that direction.
Any other thoughts?
Mr. Chair, I'm not hearing any other thoughts. And so, like I said, this is a bigger philosophical question, and I'll have different sections that have, slight language changing in it that just says, the director, will include findings in, I don't remember what I said yet because we're not there yet, but just little pieces in the rules. But really, this is something that can be captured in the statement of basis and purpose. I don't know as it has to be this, elaborate, development of rules. But I do think the suggestion that Ms. Trask made about, some modifications to Rule 306 that would capture some of this, I think would be helpful. And I think it makes our rules better. And that's really the only reason I'm bringing it up, is that if we can utilize the benefit of, local government land use processes that have been doing this for decades, centuries, then I think it makes our rules better. And so that's really what I'm hoping this year.
And I don't disagree that this might make our rules better. I'm just concerned that we're already past the statutory deadline to get this done, and we've now spent an hour talking about something that's not really part of the rules that we noticed that we're under a statutory framework to get done. So, I mean, that's my only concern is we got to get this thing done by Tuesday afternoon next week, if not today, which it doesn't sound like we're going to get to today because we haven't even got to the sum and substance of DI communities, ESPs, or cumulative impacts mostly. So I don't know. I mean, I'm not against it. I mean, I think these are good ideas, but I do want to follow through and get done what we need to get done on very, very important topics that have never been addressed before this commission. Ms. Trask?
I might ask Commissioner Messner another clarifying question. Is this something that can be resolved with just you discussing with the planning staff? Is there something currently lacking in general in the director recommendations that could just be an internal process change that wouldn't have to be
so I don't want to belabor this point anymore. I mean, I think I've made the point. I do think how we apply the rules are important. I think it's how we apply the rules are important to how we are implementing the other parts of these rules that we're contemplating here. And so this is why I bring it up in this rulemaking. The rulemaking is the opportunity for me as a commissioner to share my thoughts on topics and to provide direction. Outside of a rulemaking, it's inappropriate for me to talk to planning staff and provide any direction. And so that's why I'm providing it here in the rulemaking itself. But I would like to move on if, and just see if we have time to come back around to this at some point. So.
All right. Seeing nothing further, then what is the next appropriate spot to focus the commission's attention this afternoon? Go ahead and raise your hands. Commissioner Oath?
I have one other piece in 304, if I may.
Yep.
And I mentioned it earlier, so I think in oh dear, C19 is where I would like to see us add the language similar to what's we added in the geothermal rulemaking hearing about consulting with the community liaison about whether or not there's a local community-based organization, and if so, that the operator will work with that organization on providing notice and distribution of notice and information to community members.
Once Ms. Stafford is done typing, does that capture the thought that you had there, Commissioner Oath?
Yeah, I think so. Thank you.
Moving on. Commissioner Messner?
I do have one, and I might be confused here, but I'm looking at alternative location analysis criteria, so it's back a little bit, but B, Romanet 10. Did we talk about this being a half mile of an RBU unit, high occupancy building area, school facility outside of a DIC and 4,000 feet of an RBU located within a DIC that would require an alternative location analysis, or am I confused here?
I don't think this one was specifically talked about because initially the criteria was removed and then brought back in upon the discussion.
If I may, yeah, just to clarify, so this Romanet 10 is part of current rule language that was initially struck, but was now brought back in based on the commission's initial direction. So there is a good chance that the distance radii that we were talking about in the hearings, I guess a week or two ago now, that this was not addressed as part of that.
Okay, well, I will recommend, for consistency's sake, that, you know, and all we're asking here is for an alternative location analysis, which, you know, at one point was contemplated for all OGDPs. And so here it may make sense to have the half mile and 4,000 feet contemplated as a trigger for an alternative location analysis because of proximity to residents.
I think that makes sense.
I've got another C19 potential edit. C19C. I think that has to be more specific. I think right now it says as applicable, and I mean, I'm assuming that means the half mile and the 4,000 feet, but it may need to say half mile of RBUs outside of a DIC and 4,000 feet for RBUs inside, or I guess that one says a mile. So I guess I'm trying to understand intent on that one. And I know that for some of them, and maybe the community outreach plan is one of them, there's staff has written it as a mile for DICs, and in other places it's 4,000 feet. And so maybe this one's a mile, but it may need to say RBUs, HOBUs, schools, childcare centers, half mile outside of a DIC, 1 mile inside of a DIC. Unless you think as applicable works.
So Commissioner Messner, if I understand the suggestion, so we would take basically what's written out in subpart A here and add it to C to make it more specific?
Well, I don't know. I'm asking if anyone else has, if it's confused, because I don't know, as applicable, what is it applicable to?
I'll just weigh in and say, yes, I think that would be helpful.
Okay, we done there?
Under D5, and I'm wordsmithing here a little bit, but it says 1 mile of a building unit or high occupancy building unit within a DIC, and I think it needs to say residential building unit or high occupancy building unit.
Ms. Trask?
Thank you. Yeah, I wanted to flag that there in the draft rule that we issued this morning, there are a couple instances where we specified residential building units, high occupancy building units, school facilities, child care centers, and some places where we specified building units, which includes RBUs and HOBUs. Schools are included in HOBUs and childcare centers are included in HOBUs, but building units also includes commercial buildings. And so I might ask the commission to consider sort of across the board, is there a way we can standardize what is the suite of building units, residential, commercial, single, high occupancy? Is there a way that we can sort of create a standard language to use throughout the rules, throughout the 300 series? Because I feel like we're sort of here and there, we're not quite being the same across the board, and it might just be easier to standardize everything. And my suggestion might be to just use residential and commercial building units, or something like that that encompasses all of the things that we're trying to protect.
I mean, I think that makes sense.
I think having standardized language is good, whatever that standardized language is, and then just using it all.
I think based on our existing definitions in the 100 series, and apologies, I'm just going to read this. A building unit shall mean a residential building unit and every 5,000 square feet of building floor area in commercial facilities or every 15,000 square feet of building floor area in warehouses that are operating and normally occupied during working hours. I think if we say building unit and high occupancy building unit, we kind of cover all the bases. I'm going to scroll down to high occupancy building unit in our 100 series. High occupancy building unit means any school, nursing facility as defined in statute, hospital, life care institution as defined in statute, or correctional facility as defined in statute, provided the facility or institution regularly serves 50 or more persons. It also includes an operating child care center as defined in statute, or a multifamily dwelling unit with 4 or more units. And so if we say building unit and high occupancy building unit, I think we're covering all the bases.
All right, with the comment bubble, are we good?
So I'm happy to move on to 306. And I'll just acknowledge Ms. Trask's suggestion in 306, but I won't go down there. But there were some, I want to just make a comment that there were some stakeholders that in many different places in the draft recommendations, and this is primarily allied local governments, made a suggestion that it in areas where it says that the application protects and minimizes adverse impacts to public health, safety, welfare of the environment, and wildlife resources, they made a recommendation that it highlight direct and cumulative adverse impacts to public health, safety, welfare of the environment, and wildlife resources, so that it protects and minimizes direct and cumulative adverse impacts. I acknowledge that the definition of minimize adverse impacts addresses indirect, direct, and cumulative impacts. And so it's captured in the term minimize adverse impacts. But I throw it out there to other commissioners whether they think it's helpful for clarity to include direct and cumulative impacts as part of minimize adverse impacts in areas where minimize adverse impacts is utilized throughout the rules, or whether folks are okay with it just saying minimize adverse impacts. I'm generally okay with utilizing minimize adverse impacts because I know that that includes indirect, direct, and cumulative impacts in the definition, but that doesn't mean that it's particularly clear as we look to ensure that our rules are, somewhat plain language for people to be able to understand. They may not understand that minimize adverse impacts means, direct and cumulative impacts. And so I put it out there as a point for discussion. So I bring that out.
Other thoughts, commissioners? Commissioner Cross?
Thank you, Mr. Chair. I understand where Commissioner Messner is bringing this up, but given it's also part of our statutory language as well, I prefer to just stick with the defined term and continue to use it throughout. I guess I could also say, I think if it's truly in an effort to help with the plain language, then I think discussing even things like direct, indirect, and cumulative would also have to be kind of fleshed out as well. And then it starts to become almost an exercise in futility. That's why I think it's best to stick with the defined term.
I think that was kind of the approach I was taking under the 604 approach that I suggested this morning. I still think there's room for opportunities to further refine this in a different rulemaking. And I will take my lawyer's advice about, where we are on this at this point. Commissioner Oath, Commissioner Ackerman, anything further? Commissioner Ackerman?
No, my thoughts were right on line with Commissioner Cross, so I appreciate him expressing them.
So I've got another one in 306. It's in the denial section of the NOx intensity targets. And so B3, but so just a general question here, but it says in there, and I think Chair Robbins maybe addressed this. It says shall, or it says may. Many stakeholders are recommending shall, and to deny it if they're not meeting the requirements of the commission rules. I'm trying to think of a scenario where a director would choose to not deny it if it doesn't meet the commission rules. And so it seems like it should be a shall, but maybe I'm missing something is why there's a may there. But if it doesn't meet the commission rules, I don't know how it gets approved.
Well, I had focused on a different section on may and shall, and or will, actually, it's will and may. And the will that I articulated this morning provided the director needed to take a mandatory action, but it retained in the director discretion as to what that action would be. Moving this may to a will, I think, removes discretion to director, which is sort of a fundamental component to our rules that I think is important. I also don't think it diverts the director from denying when denial is appropriate. So those are my thoughts, that I think this may should remain a may. Others with thoughts? Commissioner Cross?
Thank you, Mr. Chair. I agree, and I think it opens a possibility to allow for certain conditions of approval, or are there options to require them to try and meet it, even if they haven't shown their ability to comply with it yet. So I agree with leaving it to commissioner discretion. I agree with Commissioner Messner. I find it hard to imagine a scenario where if it's not meeting the rules that we would approve it. I know if it's not meeting the rules, I'm not going to approve it, but I do think that this is an appropriate level of director discretion.
Well, let me ask a question there, because I'm trying to understand why there is a may, and I understand director discretion, and I understand conditions of approval and applying conditions of approval. But is that why there's a may there? Because there is a section for conditions of approval, I think, and the director can always provide conditions of approval. And so I don't know. I don't understand what other discretion there would be. So, but maybe I may not be thinking about something. So I'm just asking the question that may help stakeholders better understand why there's a may instead of a shall, if we have examples of why there needs to be a may and how that discretion gets applied.
Commissioner Oath?
Sorry.
Go ahead, Commissioner. After Commissioner Oath, would you like to go first, or would you like to hear from Attorney General Stafford?
Let's let AAG Stafford go.
I just wanted to make a brief comment about this particular rule. This is current rule language. Staff did not, this is not a suggested change to May. This is how it currently exists in the rules from mission change. So I just want to make sure everybody understands the baseline here.
Well, I appreciate. Go ahead, Commissioner Oath.
Okay. Well, I don't know that this is going to change the conversation in any way. I would just say for my part, in 306 and 307, I was generally in favor of providing this discretion for things like exactly what Commissioner Cross identified, like if there is a pathway for conditions of approval. And yes, there is the section 2 actually is on conditions of approval. So I was trying to scan it for, I think it still makes sense to keep the May here for that reason. But I'm glad we focused on it because I did not catch this. The part that is in red line is sort of written in a way that creates a burden for the director, which I think we have in other cases wanted to make sure that we're framing this as the operator's burden. So I wonder if we actually want to tweak this so that, or the operator has not demonstrated an ability to comply with NOx or greenhouse gas intensity targets.
I like that. I think what's happening is so this red line was inserted because these are new categories of criteria that need to be complied with. And so I think what the insertion does is highlight both the point Commissioner Messer was making and then the point you were making. And so while it's a struggle to get through it, I think we're doing a good job of trying to do that. And now that new language puts the burden back on the operator for the director to make a determination. But with all that, I'm still somewhat for the reasons that I indicated, I'm comfortable with the May here. And just in general, I would generally state that I'm not inclined to revisit process pieces that are not part of the current rulemaking, like they weren't part of the red lines, et cetera. That doesn't diminish the importance of continually process improvement. And I think Commissioner Messner, you're doing a good job of establishing what process improvement could look like.
Well, and just so you know, Chair Robbins, I'm reading these rules holistically, and so I'm not looking at the red lines when I'm making these comments, and so I'm applying it as best I can, not knowing what's new and what's not new, and so that's why maybe I'm hitting on some existing rules as I look at it with the inclusion of the rules. But
yeah, no, and I appreciate that, and you led with the fact that you were working off of a clean version. And if that's the case, then there's no way to know what's new or different. Let's take a break. We've been going at it for an hour and a half. This is not easy work. It's 3:27. Let's return at 3:40. Okay, welcome back, folks. This is the ECMC. We are continuing in our discussion around the rulemaking that has been before us on cumulative impacts and enhanced systems and practices. Commissioners, just check in on timing and or the work that we have ahead of us. We're at page 20 of 63 pages of rules. That's not including the rules that I drafted, so probably 20 of about 68 pages of rules. It is 3:40. We generally go till 5. We have next Tuesday set aside for a full day of rulemaking, which is good. However, what we were trying to do today was to get through the rules to get some sense of consensus and or provide direction so that staff could not only sort of correlate a final version, but also work on the SBP, because I would anticipate that some of us, if not all of us, would like to see the statement of basis and purpose that correlates with the rules. So I just throw out there, I'm not sure how the time we have correlates with the tasks that are at hand. And I'm not trying to cut off any commissioner or any discussion, but I do wonder if we should focus on sort of the essential pieces of the work before us, which is all the things in our cumulative impacts and enhanced system of practices in DI communities, and put a pin in all these good ideas around process. But I'm just one commissioner and I'm not trying to dictate anything. What do y'all want to do? I told you it was a tough problem. Commissioner Cross?
I think I'd be in favor of hitting some more of the, I'll call them the more substantive issues, like the 604, 316 type issues. And then, kind of seeing where we are as we get through those, maybe turning back to some more of these, I don't want to call it line by line, but more of the reg by reg issues as they come up.
Well, I don't know that we need to discount trying to move through it sequentially, but why don't we just try to move through it sequentially and really hit sort of the high items, the sort of essential items as opposed to tangential items, if we could do it that way. And let's just see how much we can move through. I also, as one commissioner, don't have a hard deadline this afternoon and can go later than 5 if necessary. So that's ahead of us too. And maybe we can buy another hour there. Well, let's keep going. I think we're at rule 308. Any commissioner with important topics on 308? And I can't see all the commissioners, so you're going to have to pipe up if I'm missing people. Okay. Seeing none on 308. And Ms. Trask, you are considered, have the ability to weigh in on if things need to be talked about.
Yeah, thank you, Chair. I actually would like to ask for commission direction on 308. As I stated in my presentation this morning, I'm just trying to scroll to find the language. It's under 308C2, when the director may require additional information. And then subset B there, the director may require the operator to submit a cumulative impacts analysis. I'd like to ask the commission to consider also adding language that allows the director to require the operator submit a Form 2B if it is necessary to understand the cumulative impacts. We have language like that in Rule 312. I would just like to include language like that here in 308 as well.
And that sounds like that's kind of a consistency approach, given 312 and what it's trying to address.
Yes, that would be my approach.
I'm comfortable with that discretion to director language.
Sam.
Thank you, commissioners.
.309 post completeness consultation and community meeting. We massaged through this when we gave direction back. Does any commissioner have concerns with regard to how it's drafted, the notices, the time frames, the distances, the outcome? Anything with regard to consultation with CPW or CDPHE? And then we've got the results of the communication with CDPHE. Oh, Ms. Trask?
Thank you, Chair. Another one of the issues I raised in my presentation this morning is around 309C. Let me see if I can find the exact. Yeah, so 309C itself, the post-completeness community meeting, if any building units or high occupancy building units are within 2,000 feet of the proposed working pad surface, I would ask the commission to consider changing that 2,000 feet, which is the trigger that requires the meeting, and moving it to the 1/2 mile and 4,000 feet as the trigger. This would be consistent with what we have in the pre-application community meeting.
So pre-app and post-app would be treated the same?
Correct.
Seems like a good consistent catch. Does anybody have concerns with that?
I think that makes sense.
Okay, thank you, commissioners.
We should have let you run this meeting quite a while ago. You're knocking us through a couple of things real quick.
I think that's all I have.
Subsequent operations on existing wells, 312. And this is similar to what you just changed on 309. Is that right, Ms. Trask? In terms of the potential for a cumulative impact analysis?
Yes, that's correct. It includes
the Form 2B.
Form 2B, yes.
All right, commissioners, Rule 314, comprehensive area plans. Raise your hand if you have any pondering on that. Commissioner Messner?
So I have a question and then I have a suggestion. So I'll start with the suggestion. So I'm down on G, which is the director's recommendation on the comprehensive area plan. And I'll just indicate that this is one of those areas that I think it's important to, have findings, but I think there is a mistake in here perhaps, and I think it's probably an existing language, but under the director's recommendation for approval, the director may recommend the commission approve a cap that protects and minimizes adverse cumulative impacts to public health, safety, welfare, the environment, and wildlife resources. That's a place where cumulative is actually utilized, but I think it needs to stay as minimize adverse impacts in order to capture the full array of indirect, direct, and cumulative impacts. That's part of the minimize adverse impacts definition.
I agree.
You want to make a note there, Ms. Stafford?
And then just a clarification. So I appreciate the presentation that Ms. Trask gave this morning about applicability of Form 2Bs and cumulative impacts analysis associated with individual OGDP locations and caps that are looking for preliminary siting, and then the Form 2F for applications that are not looking for preliminary siting, and then the kind of changes in circumstance that may require additional information depending on when OGDPs actually get approved or applied for. But I guess in all of that, you know, is there, I'm losing my train of thought here for a second, but, you know, is that all, is it captured the way that it needs to be captured in the rules as other commissioners are looking at it? And do they understand that to be true the way that Ms. Trask identified it in her PowerPoint? And so I just, because I'm having different stakeholders communicate to me different things about how they see that cumulative impacts analysis and Form 2B and Form 2Fs apply to different places in the rules. And so it's a question because it is important so that it is clear both to operators and anyone else of what the submittal requirements are for different CAP applications. And so does everyone else think it's good? And I asked Commissioner Cross in particular because this was your baby.
I'll say I was happy with the red lines the way that they were.
Okay, I just throw it out there because there's a couple of folks that have reached out to me with two differing views of it, and so I understand it, but I'm also more used to reading the rules. So my only other question, and this is probably for Ms. Trask, but you know, we talked about the pre-application public meeting process. Do you just anticipate that happening in CAP applications at the OGDP stage?
I would. Let me see if I can articulate your question. I apologize, I was typing. Are you asking if there would be a pre-application community meeting for the CAP and then pre-application community meetings when the subsequent OGDPs come in?
No, I mean, there is no pre-application meeting in the CAP rules as drafted right now.
There is.
Unless I'm missing it. I know that there is a meeting that's required, but it's just a meeting and it almost seems to indicate that it's post-completeness. And so I'm not hung up on this. I was just wondering if you were intending that pre-application meeting to just happen then at the OGDP stage or how you saw that work.
314D1 under submission procedure, an operator will request a pre-application meeting with the director prior to submitting CAP application.
Sorry, I'm confused. I confused you. I'm sorry. Pre-application community meeting is what I was saying.
I think our intent is that there would be a pre-application community meeting for a CAP application. If we neglected to add that here, then I would encourage that we do add that in now. The intent is that there would be a pre-application community meeting for a CAP.
Okay. I didn't see it, but that's why I was asking the question. So I think it would be a great addition if it wasn't intended to just happen at the OGDP level. So.
Okay, so we're capturing this point in a bubble. Good catch.
Commissioners, if I might just, there was a numbering issue that I found as I've been reviewing the rule, this particular rule. So in 314E10C here, water resources, this when I accepted the edits, I think it brought the language sort of back a level. So I just want to make clear that we're not intending to delete any current language here, and I would just request your okay that I make the change back to make sure that water resources is at C. Then we have Romanet I with the this language here with the red line language, and then we would have double A through double D to capture the different resources here. So that would put it back in line and ensure that there were no issues with current rules.
Okay.
And Mr. Chair, I have a comment about that same section when we're ready.
Go ahead.
Thanks. AAG Stafford, if you'll scroll back to the numbering issue that you were just at, back to terrestrial and aquatic wildlife resources and ecosystems, that's 315A to D. And then I believe if you'll scroll down a little bit, E is biological and science and soil resources. I wanted to just mention at this point the issue that I brought up about trying to get a better idea of how we're doing with regard to surface disturbance, being able to map that more appropriately in our online GIS tool. And in these two regulations, we require quantitative reporting of total acreage of new or expanded surface disturbance, including high priority habitat and other potential habitats impacted. I think it would be a good idea to require this information include a GIS shapefile. I don't know if we can hear from staff if that's currently the practice or if it's the anomaly, or if it even needs to be in regulation, but it certainly would help our online mapping efforts if we're able to get shapefiles with each application. Ms. Trask, I don't know if you have any information on whether that's the norm already.
Commissioner, we get GIS shapefiles only for the locations as part of the OGDP application. I'd be curious what shape files you would be looking for in a CAP application, like the entire 50 square mile area, or just the surface locations that are seeking preliminary siting approval. If you could, I'm happy to add it in. I think it would be good information to have, but I think because some CAPs will have locations that aren't really fine-tuned yet, I don't know that we could require a GIS shapefile for a proposed location until the operator knows roughly where they want it to go.
Yeah, that makes some sense, and kind of talking this out as we go. But what I'm looking for really is total acreage disturbed, not necessarily, a complete mapping of the impact or the area of evaluation. To me, that would include the types of areas disturbed. So the total of area of surface disturbance is what I'm looking for here. And then that would be a breakdown, how much of that is within high priority habitat, how much of it is roads, how much of it is pad, those types of surface disturbance acreages that we could then categorize and report on in the cumulative impacts report, and also include in our online GIS tool. Does that make sense?
I think so. I would ask, do you mean total surface disturbance that is being proposed within, the new disturbance, or are you looking for the operator to provide information about existing surface disturbance?
Thank you. I'm looking for surface disturbance. I mean, obviously, I think it's important that we try to get our arms around total surface disturbance. But what I would be looking for from the operator is their own surface disturbance of that oil and gas operation on a project by project basis. And I understand that that may not be available up front, and whether we need to do that, in a reporting fashion up front on an estimate, and then on a back end have them submit GIS files. Really what I'm looking for is actual, as real time as possible, surface disturbance of each oil and gas operation as it goes in, and the type of surface disturbance, i.e. is it a road, is it a pad, and is it impacting high priority habitat, and those other key factors that are asked for here. And so procedurally, I'm not sure exactly what the best way would be to do that. And if I'm going down a rabbit hole needlessly here because they're all submitted in GIS files already, I can accept that as well. But I think it would be good for us to normalize the submission of GIS files of actual surface disturbance at whatever point in the process is possible, so that we could include that in the future on our mapping tool and include it in cumulative impacts reporting.
Okay.
I don't have.
Would
Sorry.
love to have a conversation with our GIS team to make sure that I understand what would be appropriate for us to request through these rules.
Thank you, and I appreciate that segue. And if I might, Mr. Chair, it lends to something that I had in my mind to either include as direction to staff or to include within the basis and purpose statement, although it may not be appropriate there. I continue to think it's important to do our best to get around, certainly get our arms around current surface disturbance of oil and gas and put it on a map in a viewable format, as well as previous, existing surface disturbance that's unreclaimed, and certainly separate issue with reclamation acreage as well. And I think you're exactly right, Ms. Trask, that I think it will take us getting together and starting to evaluate maybe some of the tools that are out there, some of the other surface layer maps that maybe we can incorporate through our GIS program, and certainly methods by which we could gather real-time surface disturbance of oil and gas, and historic surface disturbance that's still existing in a way that's mappable and inclusive by our GIS team. And I wanted to, if the commission has interest in that, I wanted to volunteer to work with staff on that issue going forward, and agree that it would take further discussion than we can have right here. My only point here is, can we or should we insert a requirement for submission of GIS shape files? Or can we include that at some point in the Form 2B without including it in regulation? And I would probably just need some counsel from the AAG's office on those points.
Commissioner Ackerman, I fully support your concept. I have in my notes that figuring out a way in the Form 2B, as well as in submittal requirements as part of CAP applications and OGDP applications, to capture an operator's existing and newly proposed surface disturbance, holistically as much as possible. And I would go so far as to saying that, there's been some stakeholders that propose an operator providing those from a statewide perspective. That may be difficult. I do think if we have areas of evaluation, having that contemplated as, evaluating the surface disturbance of existing and new oil and gas operations by that operator as part of that evaluation, part of the 2B submittal provided in a GIS shapefile format does help us start to build that database and helps us develop that critical information and data on existing and proposed surface disturbances that I think will be critical to address cumulative impacts to a number of different resources. And so fully support that concept.
Thank you. I appreciate that. And just making sure that if the rest of the commission is in support, if we can move forward with this administratively, I think that certainly there's a lot of talking left to be done about the best path forward here that we can't do today. But the question then would remain to AAG Stafford. Can we, if we decide that shapefiles are appropriate in the submittals on the 2B, can we include that in the 2B under existing regulations? Or do we need to do a regulation that enables that?
Sorry, that question is for me.
It
Yes.
is.
Okay. I think it's my take that if you are going to be requiring shapefiles, that it needs to be in regulation. This is not sort of like a guidance document, or that probably isn't the appropriate vehicle for it. So I would recommend a regulation. If my colleague disagrees with me, I'm sure he'll chime in.
AG Davenport.
Thanks, Chair, and thanks AAG Stafford. I agree. If the intent is to add a requirement that otherwise, if not met, the application would be not complete, then it should go into regulation.
Thank you. Then my suggestion for the commission to consider would be if we're talking about, if you'll scroll up there, if you would please, to D, terrestrial and aquatic wildlife. The required information under Romanets I, and the third one, I may not be applicable, but I think we could get to where I'm trying to go by simply requiring that a GIS file be included with the information that's already required by this regulation. And I don't know that it would be that easy to include it in biological and soil resources, but conceptually, any habitat information that's suggested or that's required by these regulations should include a GIS shapefile. And I'm ready. I'm more than happy to move on from there, Mr. Chair. But if there's any trepidation about the inclusion of requiring a GIS shapefile for information that's already required under this regulation, I'm happy to chat about it. But otherwise, I think
Ms. Trask has her hand raised, so she may want to chat with you.
I'll try to be quick because I think we probably should move on. I think there's going to be a lot more discussion on this, but I would flag that for Romanet 1, little I, that seems duplicative to me with what we already have in our GIS layers. That is sort of just looking at existing high priority habitats. So I'm not sure that a shapefile for Romanet 1 is appropriate. I think a shapefile for Romanet 2 is more appropriate because that is the operator's proposed surface disturbance. So I might make that clarification. And then we also, in 304B8, this is where it's current rule 304B8, we require GIS shapefiles on each Form 2A. I would maybe suggest that for locations that are seeking preliminary siting approval, the operator could submit that GIS data. Actually, that might already be a requirement in our rules now that I think about it. I think we already do require the location shapefile for locations that are being locations where the operator is seeking preliminary siting approval. So that would come in with the cap. One thing I might recommend, and I don't want to belabor this too much longer, but in that rule 304B8 in the OGDP, current rule requires that the GIS polygon describes the boundaries of the entire proposed location and the working pad surface. I might suggest that we add in the requirement for the operator to submit the shapefile for the access road and any off-location flow line or pipeline or utility corridor. That would help us gather more GIS data about what the proposed new surface disturbance would be.
Yeah, thank you. I certainly appreciate the knowledge at your fingertips there. It's really helpful and a good astute thought. I guess my last question then would be, under that method that you just set forth, would that then already include a breakdown by acreage of the current types of land use, the number of acres of new or expanded surface disturbance within high priority habitat, and it would with regard to the Wells high priority habitat. So as opposed to just including a requirement for a GIS shapefile under Romanet 2, as you suggested, I'm asking, would the other method that you just talked about include these same breakdowns?
I wish I knew enough about GIS to answer your question. I'm sorry, I don't know. I don't know enough about GIS shapefiles to know. I have a feeling that it would require multiple shapefiles that are specific to each topic, so
thank you.
Yeah, I don't think it would work with one shapefile. I think it would require sort of a suite of shapefiles.
Right, thank you. So, Mr. Chair, what I'm hearing here is there may be enough trepidation associated with insertion of a requirement for a GIS shapefile at this late stage in the game, but I would suggest that if it's all right with the commission, that I can get together with staff at some point after the conclusion of these hearings and talk about more surface disturbance issues and the potential approach to shore that up.
I'm in favor.
I agree. Thank you, Commissioner Ackerman.
Okay, where are we going next?
$315. So I'm happy to start here quick on 315, and it's just a simple one. In 315A2, which is resource impacts. I do think it's important. I understand that Commissioner Ackerman wants to work on it after the rulemaking. I think we have to capture some of the surface disturbance pieces as possible in our cumulative impacts data and analysis processes here. So I would like to continue that conversation, and I don't know when we can do that, but I do want to acknowledge that I do think it's important in this section as well. However, the simple one here in the resource impacts is we heard a lot of feedback from stakeholders about the need to both to provide more quantitative data, in the Form 2B. And so a suggested red line to this section of resource impacts on the last line would just be, for all required evaluations, the operator shall submit quantitative data on the Form 2B unless quantitative information is not reasonably available. And so I make that suggestion so that we're capturing, I think, a desire from many stakeholders to see more quantitative data. I think it helps build our database in a more useful way, but it also provides the ability that if it's not reasonably available, that qualitative would be able to be substituted in place of quantitative. And there are areas where qualitative is required in the rules as well. So it's asking for qualitative and quantitative as in certain areas as well.
I'm supportive.
Anybody got concerns?
Just have a question. Would it make sense to potentially include that in the SBP, just to say, because it seems to me it's sort of clarifying language as to the rule's intent. So just putting it out there. I'm not sure I have a concern with it being in the rule, but just suggesting the SBP as well.
Commissioner Ackerman?
Oh, go ahead.
Sorry, Commissioner Messner, I didn't mean to hijack your issue here. I do think the way that it's written currently in the regulations puts quantitative and qualitative data on equal footing. And I think if I'm hearing what Commissioner Messner is saying, I agree with it that that the leaning should be towards quantitative data where and whenever possible. And I think that including that in the regulation might be appropriate to help make that differentiation.
Commissioner Messner?
I agree.
For
All
a
right,
clarifying
let's-
question to understand how this would work.
Go ahead.
So, would this be applicable for all of the sections here? It is, okay. And I guess I'm just trying to understand and track, because similar language to that is in the biological resources section. But then in other sections, like for example, the air resources, right, it's specifically calling for quantitative information. But then so then I'm not sure if I have a good example, but like, so I guess the way this would work, if I'm understanding it right, is somewhere where it's saying, like, here's one, a qualitative evaluation of potential impact to a public water system intake. Would this new language now be basically usurping that and saying, no, you've got to provide quantitative unless it's not available, then you can provide with that, and you'll have to provide qualitative, or I'm just not sure.
So from my perspective, what it's saying is it's applying the reasonableness standard to it, right? And so it's essentially saying that, you know, quantitative is what we're going for in almost every circumstance, but if it's not reasonable to provide the quantitative, then qualitative can meet that standard as well. And so that may be an example where, and some of these rules have fleshed out, at least in the mission change rulemaking, when it was kind of unreasonable to do quantitative, but some of them did not. And I think we fudged a little bit in the mission change rulemaking to a lot of qualitative. And as Commissioner Ackerman talked about, we've put qualitative and quantitative on equal footing, you know, in some places in the rules as well. And so again, this clarifies that quantitative is the preferred and default, and that, you know, in lieu of quantitative reasonably being able to be provided, then qualitative can be substituted for that.
Commissioner Hurth?
I think I just need to think about it for a bit. I mean, I totally agree with that concept. And I guess I had always been thinking about this section as having kind of already worked through that, like where are the areas where quantitative is reasonable. And so therefore it's like specifies and it's asking for quantitative information. And then those areas were not, that it was saying qualitative, but I haven't looked at it from that kind of perspective to ensure that that's just kind of how I've understood it. And so I think what you're saying makes sense. And as AAG Stafford said, maybe is just a kind of a clarification of what the expectation is here, but just trying to understand how and whether this would change what is being, the requirements of what would be submitted.
If I may.
Go ahead.
Oh, I'm sorry. I think I just froze there. I think after hearing Commissioner Ost's concern, that is a concern a very clear concern I see, and I would have some trepidation about incorporating the proposed sentence into the rule. I think it would introduce some confusion now as we're looking through the rule, and there are numerous places where staff, previously had drafted, we are looking for a qualitative evaluation of for a particular resource here, and I'm concerned that by the sentence that is being suggested might honestly just introduce confusion and sort of where there doesn't need to be any additional confusion.
So given the fact that quantitative is used in certain places, qualitative in certain places it's both, you would suggest that they once again suggest to put this back into the SBP so that it doesn't carry unintended consequences. Did I get that right?
I think my suggestion, yes, would be language in the SBP to state, obviously the commission staff is looking to see quantitative information where possible. And we've specified throughout this particular rule that the types of information that we're looking for, whether it be quantitative or qualitative. So just sort of making that clarification within the SBP would be my preference.
Mr. Chairman?
Yeah, I can't see everybody, so just go ahead and start talking.
So this was an attempt to try to make it simpler, but in lieu of that, I think we can go to each of the resources and determine whether or not quantitative or qualitative is appropriate or not, because there, for example, public welfare, it says a qualitative or quantitative evaluation of incremental adverse or beneficial impacts. And so they could do either to meet the standard. In the terrestrial, aquatic, wildlife resources and ecosystems, it talks about a quantitative or where quantitative information is not reasonably available, a qualitative. And so this would just do the exact same thing, but it kind of applies it throughout. And so there's different areas. And if I remember the mission change rule making correctly, the qualitative and quantitative wasn't staff derived. It was actually stakeholder derived in determination. And there were certain sections that it was questioned whether there was quantitative or qualitative that was necessary. And where there was a question, we did qualitative. But I think we've got feedback from stakeholders at this point that there are areas where quantitative may be more helpful in determining and developing the data necessary to be helpful to evaluate and address cumulative impacts. And so this is why I bring it up. But that's just my thoughts on there. I mean, I can provide specific examples to specific resources if a blanket one doesn't seem to work.
If I may, commissioners, staff is always in favor of quantitative data where it's available. In the database, in CIDR, in the Form 2B, the way we've set up the data fields to collect the data, we prioritize data fields that have quantitative data. So distances, numbers of things, sizes of things, counts of things, volumes of things. The problem is that some of the resources that we're reviewing here, there is no quantitative data. And so the next best thing is to capture a qualitative assessment of it. I can see only a couple of places in our current rule where we could require quantitative data, and that would be in public welfare. Under noise, we could measure decibels. That starts to drift into the noise mitigation plan, which is a pretty comprehensive technical plan. And light, where we could get data on lumens. That is also overlapping then the light plan. And so as much as possible, staff would love to have quantitative data, but for things like odor, I don't know how to measure that. Dust, we're getting particulate matter, but I don't know how to measure dust. And I don't know how to measure recreation and scenic values, for example. So we always strive to get quantitative data where it is available, but it's just not always available. So the sort of the, backup plan is to use qualitative data in lieu of using nothing.
So I give up. In the language itself, it says, if it's not reasonable to do quantitative, then qualitative would be fine. I tried to make it as simple as possible, but I give up.
Commissioner Ackerman?
Thank you. I agree. And we definitely have moved this direction over time. And it sounds like it certainly is our intent, both from a staff perspective and a commission perspective, to continue to move this direction. Is there any merit to including language, as Commissioner Messner talked about, into resource impacts that mirrors the language in wildlife that essentially says quantitative, or where it's not reasonably available, qualitative, and then strike quantitative and qualitative underneath in all of the subsequent bullets? Or does that just create confusion for the operator and maybe put us in a position where we're getting different types of data from different operators? And that would be my concern as well. And so as I thought through that, I guess AAG Stafford's ahead of all of us here. That I've circled back to a statement in the basis and purpose, particularly associated with resource analysis here. And I would want it to be explicit that staff prefers quantitative data whenever and wherever available. I do recognize that I think that leaves, maybe some potential untapped value in our regulations. In the areas that I'm most interested in, quantitative data is included already. And so I think we can further analyze that maybe from a staff perspective, but I really appreciated the discussion as well.
Mr. Chair, I don't know if you can see me, but I have.
I cannot. Go ahead.
I think that the flag on public welfare of that OR is the one that stands out to me that has some ambiguity here. So I think otherwise it's fairly clear of what we're looking for. And so I don't know if others, I think it might make sense to, in that particular case, add the language that's similar to what's in D and E for terrestrial and aquatic wildlife resources and biological and soil resources, first saying, clearly expressing the preference for quantitative information, and then where it's not reasonably available, then qualitative evaluation.
All right. Looks like we're getting there.
Sorry, just to check in, does that, I guess that comment bubble capture what the direction is.
It's consistent with my comment, but I want to make sure other commissioners agree.
I'm good. Everybody else okay?
Yep.
All right. Where are we going next?
I have a couple of things in 316B, unless someone has something before then.
Anything else on 315?
So, Mr. Chair, I would like to emphasize that, I think it would be helpful to have submittal requirement on the Form 2B of the operator's service disturbance as a separate section. I don't want to go into the details of that right now, but I would hope that if Commissioner Ackerman is going to do work with staff in developing how to best develop the information necessary to improve our data so that we can look at total surface disturbance of oil and gas operations in areas of the state, which I think is of critical importance to evaluate and address cumulative impacts that we think about here, between now and Tuesday. If there is submittal requirements that are part of the Form 2B that an operator can provide, that would be helpful to start collecting so that we can start to utilize this data in a way that helps us evaluate and address cumulative impacts from a surface disturbance standpoint. And so I throw it out there, and because I think it's important that we not ignore this need to develop surface disturbance data. And this is a tool to be able to do that, this rulemaking.
And Mr. Chair, I don't know if you can see me, but I've got my hand up as well.
Go ahead, Commissioner Ackerman.
Thank you. And I concur. I do worry about us going down a road of, undertaking this critical information gathering process and then not having the teeth together the information that we need. I would note that the wildlife hunting and angling groups submitted a red line that does very closely what Commissioner Messner is talking about, although it includes pipelines as well, which I would question. But I'd be happy to put together a red line based on that red line for evaluation, if that would work.
I'm looking around to see if anybody wants to weigh in. That sounds good to me.
Chair, I would be happy to work with Commissioner Ackerman in the next few days on that red line. I'm happy to provide sort of technical CIDR and GIS capability input where I can.
So I have one other thing in 315.
Go ahead.
And let me just make sure I've been 315 before I say that. Yes, I've been 315. And so I talked about this, at the last meeting. And there's still the inclusion in this draft rule and this is in the director's review of the area of evaluation. I'm uncomfortable with this commission deferring to the director with applying clearly erroneous standard. I have no reason to think that the director would do something that would be clearly erroneous. At the same time, you know, we are an independent review body of an application and need to maintain that independent review authority, and are separate from staff in reviewing of the application from certain perspectives. And so I think it's important that that not be there. And so I propose the striking of section 5, Romanette 5, from the draft rules.
Mr. Chair.
Yep, Commissioner Cross.
I think it's important to have a level of discretion left to the director's evaluation. I think that, again, provides certain regulatory certainty so that we're not coming forward and having to potentially change things at a hearing that's been prepared in a completely different manner. I do remember us talking about the standard in some of our discussions. I don't remember if the clearly erroneous was something that we came to a consensus on, but I do think that it's important to have some level of discretion left to the director on that issue to make sure that we have an idea of, on everyone's behalf, of what is going to be the appropriate thing for our review kind of moving forward.
Commissioner Oath.
Thanks. You know, this is when I think this standard, as I understood it, was initially included when the process was quite different for the area of evaluation. And I think with the changes now, it's, you know, really the burden being on the operator. You know, we have the default numbers, but and then and then there's sort of this discussion between the operator and the various agencies. And then, if I recall, there's language saying that the operator should defer to the director, and maybe even the other agencies, or maybe just the director. So there is a lot of deference to the director by the operator. And so I think I'm in agreement that it doesn't necessarily put the commission in the same place of needing to therefore have a pretty deferential standard at this point, because the operator would be on notice from the very beginning if they are going to go with an area of evaluation that differs from the had said up front. The operator will know that all along, right? They will, you know, the rules would say they should have deferred, and if they're not, they're sticking with a different area of evaluation than what the director has recommended. I do. Well, yeah, actually, I'm talking myself in circles, because I guess there could be other circumstances where the director has comfortable with an area of evaluation, and the director and the operator are in agreement, but maybe the commission thinks differently or something. I guess that would be a different type of scenario. So I'm still thinking.
Let me throw something out there. So, I mean, I mentioned this before about the ALAs, and I went through that whole process, but I mean, here's the way that this happens in real life is, you know, the director determines with the operator pre-application meeting or somewhere during completeness determination what the area of evaluation is. I'm hoping that area of evaluation also utilizes the expertise of CDPHE or CPW as applicable. Area of evaluation gets developed. Director, in their director's recommendation, which is why it's important to have findings in a director's recommendation, makes a finding as to how they came to a determination of some area of evaluation that's different than the default evaluation. They have to make the director makes a showing in the director's recommendation, and then we as commissioners, if we're going to do something different than the director on an area of evaluation in their director's recommendation, we have to already make a clear finding in our decision that something that an operator and has a proposed and the director has agreed to and recommended in their recommendation. I mean, we have to create our own record and our own findings. And so we have to make a determination if we're going to do something different. Now, our determination doesn't have to meet the standard of clearly erroneous. And this is where I'm stuck, is the clearly erroneous piece. We have to make our own findings. We have to make our own determinations. It's true of any review of the applications. It's true of how we look at alternative location analysis or any other submittal requirement that happens if an application, if it comes to us and we determine that it's inadequate, that's, you know, that is an opportunity that we have as a body, but we better come up with really good reasons of why we find it's inadequate and how it ties to the rules. This is the exact same thing. So I don't see the benefit of having this rule only having a clearly erroneous standard. I think it sets a very bad precedent. And so we independently review the applications. I don't even know why you wouldn't defer to the director in her recommendation if she's developed a finding of why.
AG Davenport, could you visualize? Talk to me about other context, other situations in which director makes a finding that then comes to commission for it to review, make its finding based upon the finding. What are the standards that we might have already used? I agree with Commissioner Oath that perhaps it's a different context than when it was originally drafted. I agree with Commissioner Cross that it does make some sense for there to be some understanding and predictability. I guess the thing that I'm not sure I agree with is removing some parameter for our review based upon what the director has done. So striking it entirely, and I would like to shop around and see what other alternatives might exist. And so thinking about some of the other things that we may do or not do might help me in my thinking.
Thanks, Chair. I'm not sure that I can, unfortunately, provide alternative standards in our own rules off the top of my head, and I'd welcome any thoughts from AAG Stafford or Ms. Trask, but ECMC does use the clearly erroneous standard in a complaint enforcement context to overturn the director's decision there. But I'm not aware of another standard in our rules for the commission to reverse the director's decision and where the rule also sets a standard. I think it's possible to not strike the entire subpart 5 here and possibly not state the standard, but note that the commission will defer unless in the commission's determination it's appropriate to use in a different area of evaluation. Something along those lines. But I am not aware of a different standard for reversing a director or overturning a director decision other than clearly erroneous in our rules.
Okay, no, I appreciate that. I mean, I get more comfortable if we go the route that you're talking about, Mr. Davenport, without the pronunciation of clearly erroneous, but that we need to have, I don't know, substantial evidence in the record to justify coming up with a new area of evaluation. I feel pretty confident that the commissioners that I work with now will make the right decisions, but we're trying to create rules that are going to last for a while. I don't know if it's based upon, reasonable evidence in the record, based upon new information or information that is proven to be incorrect, or I also appreciate and believe that the subject matter experts that are the quote director, it's the director and all the people that work for her, probably have a better understanding of incorrectly determining area of evaluation, then perhaps I would. So I want to have that generated into the rule as well. So I don't have any answers, but those are some
Well,
thoughts.
I think you hit on it though. Just put substantial evidence in the record, and that's what we have to do anyway.
Commissioner, okay, thanks, Commissioner Messner. Commissioner Oath, you'd raised your hand.
Maybe the new commissioner kind of question, because as I understood it, as we kind of revamped the process for this, we were drawing largely from the process for the ALA, and you guys all correct me if that's not right. So that's where my mind goes is, how is it addressed there? And does it make more sense to do it similar to that, or is there a reason to kind of look at this differently?
Staff or AAG staff, or do you want to speak to that, how this might not equate to ALA?
Yeah, I'm happy to jump in on that. I do feel like this is a little bit different than the ALA, because this is my understanding per the statute, this is a geographic area that has to be determined at some point in the OGDP process. The ALA doesn't have that same level of sort of concreteness. There's a lot more flexibility in the ALA for staff to say, hey, you should add that alternative location in your ALA. That alternative location is just a no-go. You don't have to include it. Those conversations happen all the time. So, but I don't see the ALA as having the same sort of precedent, I guess, as the area of evaluation because of that statutory language. And I will say, though, that I am largely comfortable with the planning staff's expertise and ability to walk through the pre-application review with the operator, with the local governments, with community members as appropriate, with the community liaison, and come to a sound science-based conclusion about what is the right area of evaluation. I think it's doable, and I think that the director will rely very carefully or very regularly on staff to make that determination. I do think it's important, excuse me, for the commissioners to receive new information. Maybe, something happens in the 6 months that the permit's under review, and the area of evaluation has to be changed. And I think that the commission should have the authority to make that change if the director is unable to for some reason. But by and large, I put a lot of confidence in staff's ability to make that determination soundly and using science and data.
So, Ms. Trask, not to put you on the spot, I'm putting you on the spot. So what does that mean?
I like the language that AAG Davenport proposed. I don't think we need to totally strike Romanet 5. I think it would be appropriate to just change that last phrase or two, take out the clearly erroneous and add in the language that that he provided, which I was trying to capture and I didn't type fast enough, but something about the commission can change the area of evaluation. The commission should defer to the director, but where they deem it's appropriate to change the area of evaluation, they can. And AAG Davenport said that much more succinctly than I did.
So what if we do something like, and AAG Davenport, I'll just throw something out there and Commissioner Messner listen in and think through, because, I don't know, the area of evaluation may be, modified by the commission following consideration of subject matter expert of the director, as well as consideration of all substantial evidence in the record.
I'm fine with that. That's what we already do anyway. I'm having a problem with the clearly erroneous piece. That's not what we do right now. And so I'm good with that language you just suggested, Chair.
Did you capture that, Commissioner or AG Stafford and Commissioners Oath, Cross, and Ackerman? What do you think? Just pipe up because I can't see you.
I'm on board with your suggestion, Chair.
I am as well, although I don't think it got fully captured in the bubble. Sorry.
No. If we could repeat that, I
Yeah.
appreciate it.
It was commission. I think I started with the affirmative. The commission or the area of evaluation will or may be reviewed and against the expertise of the director and may be altered based upon, I don't know, consideration of that of the director's report and the substantial evidence of the record or something like that. Some verbal montage.
Might be worth a review of the tape because I appreciated your former language, Mr. Chair. So
I'm never going to say it twice. Commissioner Ackerman?
I can commit to going back and listening and making sure I capture that right.
Thanks, AG Stafford, and thanks, Commissioner Messner, for raising the point.
I'm also fine with that. I just want to make sure that we have something in there to tie it to.
So I've got another one that's still in cumulative impacts, and I think we're still in cumulative impacts. And it's under D, which is the measures to avoid, minimize, or mitigate adverse cumulative impacts. And so I will say that I hear what is being said about applicability of the mitigation hierarchy and the rules that have been noticed and some concern about that. But this one actually is a rule about measures to avoid, minimize, or mitigate adverse cumulative impacts. So if there is any place that we would be more specific about how to avoid, minimize, and mitigate adverse cumulative impacts, it would be here. And so I have red lines. A lot of the red lines came from the allied local governments, but it does specifically break down avoid in Romanet 1, minimize in Romanet 2, and then mitigate, and clearly lays out, how you avoid, minimize, or mitigate, which is exactly what the title of this one is. So I'm not sure how to present those because they're a little bit lengthy. I'm happy to read them, but this is the place where I think it most appropriately goes. Also in the statement of basis and purpose as well. And there's I'm on board with the future rulemaking that, further clarifies, where the mitigation hierarchy gets, placed in the rules and different rules than what noticed here. But this one is the rule. It is avoid, minimize, mitigate adverse cumulative impacts. So it seems appropriate.
Commissioner Messner, I was going to raise a similar wonder here and I'd like AAG Stafford to maybe help weigh in on this. given this and given the receptiveness that we had to the ALJ proposal, can we do and both? Can we, provide clarification on the 604 that I'm working on, as well as some of the other areas of the rules as a temporary fix, and then, specifically call it out here without running afoul of having different interpretations about our rules come to play.
Thank you, Chair. I think I would have to think about that a little bit more. I don't know that I'm fully prepared to answer that right now.
No, and that's fine. And let me put a pin in deliberation discussion, and let's talk a little bit about process. It's 5:00. I'd suggested we could go later. I'm never a real fan of that. I've worked with too many boards and commissions that the later they go, the decision making gets worse. I've looked at calendars. I've touched base with hearings manager Thomas. We have Tuesday, the 15th set aside all day. And we have OGDP business agendas tomorrow and Thursday. And I would like to propose that we do OGDP business agendas tomorrow from 9 to 5 and get through as many as we can. And if there are others remaining that we don't get through, we continue them to the next available business agenda. And instead we use Thursday, the 10th, as another hearing date on cumulative impacts, enhanced systems and practices of disproportionately impacted communities, which would give us some more measured time, provides close to 16 hours of additional deliberative thoughts, gives staff a little time to be thinking about the things that we've deliberated on today. We might even stop here and give Ms. Stafford a chance to sort of think about this question I just posed to her, which I understand, and it makes sense that she wasn't ready to answer. And, otherwise provides a clear path forward to getting this done by the second date that we said we were going to get it done, which is Tuesday, the 15th.
Chair,
Thoughts?
if I may jump in, I won't be available on Thursday. I will be out in the field with the Colorado Energy Office on a solar tour for the most of the day.
Well, then that whole idea is shot.
Apologies.
No, I understand. Is there a chance, Ms. Trask, that if we were to gather questions for you and find you at some, maybe some 45-minute or an hour stage at some point, where we could have you visualize in and then we could just pepper you with questions? Because there might be some questions that deserve your expertise that could arise that day. Otherwise, we could hold on to them and give them to you over the weekend or Friday.
I believe that I should be back online around 2 p.m., maybe 2:30. So I could be available late Thursday afternoon.
I think we could make that work. We need to accommodate everybody's calendars and et cetera. Folks, what are your thoughts to this idea? I'm seeing thumbs up and nodding of heads in up and down fashion. All right, well, let's put a pin on it right here. We're stopping at a good place to stop. Let's continue 240600145 to 9 a.m. on October 10th. Hearings manager Thomas, if you could alert the attorneys to the OGDPs that are sort of batting 8th, 9th, and 10th on tomorrow, that they may not get to come to the plate, and we will get to them as soon as we can. And to all the parties, we appreciate your accommodation and your continued working with us on this important rulemaking. So with that, we are done for the day, and we will continue and see everybody. And well, if you want to come in and watch us and really at play, we start at 9 a.m. tomorrow on OGDPs, which is always stimulating. But if you want to come back for cumulative impacts and enhanced systems and practices, that'll be 9 a.m. on October 10th. Thanks, everybody. Good work.